Welcome back, ladies and gentlemen. A couple of housekeeping rules. Once again, we're going to be going into a very active couple of items here. So we appreciate, number one, respect shown to both speakers, the board, the chambers, and the individuals. We do have a little problem. I understand that there was a problem with folks listening to us. We're talking away from the mic, so we're going to try to correct that up here at the board. That goes for the speaker's podium also. And I want to ask the cooperation of the folks here in the galley, if you will, and out in the lobby. Apparently there was a lot of side conversations being conducted. Folks couldn't hear, so we want to be conscious about that. Lastly, our last two rows on both sides of the audience here are reserved for staff. If you see staff come in and you're seated in there, I'd appreciate if we'd give them a seat. Now, they're going to be here presenting on their particular time slot or their agenda item, so they may not be here. They may be walking in and walking out. So if we'd be consistent with trying to get those folks in and out of here, wrong term to use. Try to get those folks in here to get their input. I'd really appreciate it. With that, I do have a change in our agenda, a brief change, and I'm going to bring up Public Works, Mr. Robert Packinger, to address something that needs to be brought to the board on an emergency basis.
Mr. Chairman, if I might, I'll introduce it and then let Mr. Packinger continue.
That'd be fine, CAO Lopez.
The board might recall that on January 24th, your board approved a resolution declaring a local state of emergency due to extreme winter weather of January of 17, particularly with respect to the county's road system. However, that resolution expires today. Our Public Works Department is very concerned that possible upcoming storms would further threaten damage to the road system. Therefore, a new resolution declaring a local state of emergency is necessary to be eligible for further fiscal assistance. Because this resolution is not on today's agenda, it is necessary that your board first, by a 2/3 vote, majority vote, authorize consideration of the item on today's agenda. Should you approve putting the item on the agenda, then it will be necessary or it is recommended that your board approve a resolution of declaration and that you, by that resolution, declare a local state of emergency due to the winter weather of 2017. Mr. Packinger is available, and I'm available for any questions. But, Mr. Chairman, what we're asking is that first, by majority vote, authorize discussion of this, consideration of this item, and then should you do that, then we will ask that you approve the resolution.
Thank you, CAO Lopez. County Council, there was mention of a 2/3 vote. Is it majority, 2/3, or 4/5?
It's a majority in this situation.
Okay.
The majority decides needs to decide whether there is an emergency situation that has arisen.
Okay, thank you. At this time, Mr. Packinger, do you want to make any presentation, or we need to move first?
Well, yes, sir. We continue to work as best we can, dealing with various road repairs that are occurring as a result of the winter weather storms. We're expecting more to happen. We don't know exactly what. We are still in winter, and as we confront various culverts that are being washed out and road situations, we'll be working on them as best we can.
Okay, thank you, sir. Any board comment or question on this?
I think first we need to have a motion to consider this item for the agenda, and I would make that motion.
Thank you, Supervisor Mills. I stand corrected on that. He did say that. I'm not perfect, folks. I got to screw up once in a while.
That's why I'm here.
Entertain a second to Supervisor Mills' motion to consider this issue. Second by Supervisor Garamendi. Public comment. Bring it back to the board. Any further discussion by the board? I'll call for a vote. Indicate your acceptance of the motion by saying aye. All in favor, say aye.
Aye. Aye.
All opposed, say no. Unanimous, pass 5-0. Thank you.
Thank you.
We will consider the issue right now. Is there any further Presentation by staff.
None, sir.
Any questions by the board? Any comments?
Would you like me to read the resolution into the
Please.
record?
Please.
Okay. Resolution extending the applicability of Chapter 17.95 of the Calaveras County Code. This is not it. Sorry.
I feel better now.
That was more like it. Sorry about that. Resolution declaring a local state of emergency due to the extreme winter weather. Whereas on January 18, 2017, the Director of Emergency Services for the County of Calaveras found that due to the extreme winter weather experienced during the month of January 2017, a condition of extreme peril to life and property does exist in Calaveras County during the period beginning on the 7th day of January 2017, and whereas the extreme winter weather has caused considerable damage to the county road system and has created dangerous driving conditions caused by the unusually heavy rains, extreme wind conditions, mudslides, and high snow levels, and whereas the damage caused by these conditions are or likely to be beyond the control of the services, personnel, equipment, and facilities of Calaveras County, and whereas the winter weather continues to overburden the services, personnel, equipment, and facilities of Calaveras County, and whereas Section 2.72.060 of the Calaveras County Code empowers the Board of Supervisors to proclaim the existence of threatened existence of a local emergency when said county is affected or likely to be affected by a public calamity. And whereas pursuant to Section 2.72.010 of the Calaveras County Code, the Director of Emergency Services has proclaimed a local state of emergency throughout Calaveras County. And whereas the Chair of the Board of Supervisors is the Director of Emergency Services in Calaveras County, and whereas the Calaveras County Director of Emergency Services does believe that these conditions are and will be present, the Board of Supervisors does desire to ratify the proclamation of the existence of a local emergency, and whereas the Calaveras County Board of Supervisors ratified the proclamation of the existence of a local emergency at a duly noticed Board of Supervisors hearing on January 24, 2017. Therefore, be it resolved that the Calaveras County Board of Supervisors does hereby declare a local emergency in Calaveras County as a result of extreme winter weather harm. As a result of extreme winter weather harm may cause to the traveling public. Be it further resolved that the County of Calaveras also requests the State of California to waive regulations that may hinder response and recovery efforts to make available recovery assistance under the California Disaster Assistance Act and to expedite access to federal resources and any other appropriate federal disaster relief programs. Be it further declared and ordered that a copy of this resolution be forwarded to the Governor of California with the request that he proclaim the County of Calaveras to be in a state of emergency. Be it further ordered that a copy of this resolution be forwarded to the State Director of the Office of Emergency Services.
Thank you, Madam Chair. Any questions, comments by the board? Saying that this is an emergency situation and the copies were not provided to the public, is there any questions or comments by the public at this time?
There are copies of the resolution on the
Okay, thank you. There are copies if you wish one, folks. Mr. Edson?
Thank you. Cliff Edson, citizen of Calaveras County. So, in the past year or so, we've had how many local emergencies declared? And why do we have them? You know, a lot of this is preventable just by us becoming a little bit more self-sufficient. And we do that by growing our economies, getting our businesses working, and getting our revenues up so that we could actually fund people like in our Public Works Department, and our Sheriff's Department, and the folks that keep our infrastructure together in this county. And for some reason, we seem to not want to let that happen in many different levels. So I would like to agree that this is yet another state, an emergency within Calaveras County. There's no doubt about it. I've seen it myself. You guys have all seen it. There's roads washed out everywhere. A lot of it, some of it is from, just overflow of water, too much water capacity, but some of it's from lack of maintenance. And these culverts that are being replaced, a lot of them are because the bottoms of them just rotted out because we haven't had the means to be able to go through and do the correct procedures or the correct maintenance on these roads that we should have been doing for years and years and years. So just appealing to the board to consider that as we move forward, open some possibilities up, maybe some things that we can do to invite businesses into the county to make it a little bit more business friendly. And let's try to become a little bit more self-sufficient so that we don't have to continuously go through this over and over and over and rely on every state, the state of California, the feds, and everybody else but ourselves. Thank you.
Thank you, sir. Any other further comment? Mr. Tuna?
David Tuno from Rancho Calaveras. I think we just heard a pro-pot argument here, and I'm sure the people all that live downstream of the Oroville Dam wouldn't have the problem they have right now if only they had grown their economies, and they wouldn't have to ask the federal government or the state for emergency money to repair the Oroville Dam. Thank you.
Thank you, sir. Further comment by the public? I'll bring it back to the board. Board comment, questions? Hearing none, I'm sorry, Mr. Packinger, do you have further comment? I entertain a motion on the ordinance and resolution, declaring a local state of emergency due to extreme weather. I would entertain that motion.
So moved.
So moved by Supervisor Garamendi. I'm looking for a second.
Second.
Second by Supervisor Clapp.
I'll
Mills.
take the credit.
You guys need to do something.
I don't have a beard.
Let's get back to our issue here, folks. Please indicate your position on the motion. If you're indicating that you want to have this motion in place on the resolution, indicate by saying aye.
Aye.
All opposed by saying no. Motion passes 5-0, unanimous. Thank you very much.
Item 27 is from the Planning Department to conduct a public hearing and adopt a resolution upholding the Planning Commission's denial of the appeal of the Planning Director's denial of commercial cannabis registration 2016-404 for Chuck Long on 1820 Meadowview Road, APN 004-033-003, file 2016-1124.
Thank you, Madam Clerk. Council, this is a appeals hearing, correct?
Correct.
Okay. Ladies and gentlemen, before we get started, I want to go through the procedure of what's going to happen in an appeals hearing, so everybody has an understanding. First, staff presentation and board questions of staff. They'll go up first and make that presentation. In this situation, it's going to be Mr. Mauer and our planning, I forgot your name, I'm sorry. But anyway, our planning department. There'll be a presentation following that by the appellant. The presentation by members of the public shall be limited to 5 minutes for each person. Please keep that in mind. We're going to go 5 minutes on that, ladies and gentlemen. Summation and rebuttal by the appellant. We're going to go to 15 minutes for each appellant. And I understand we have one appellant. Staff summation rebuttal will be next. The sure rebuttal by members of the public and questions at that time by members of the public. We have a close of the appeal hearing and board discussion and action. Okay, anybody have a problem with that procedure? Excellent. At this time, I'll open up the hearing, and we'll hear from Planning Commission.
So good afternoon to the Board of Supervisors. This is Miguel Contreras with the Planning Department. I'm here to present 2016-1124. This is an appeal of the Planning Commission's decision to deny this registration for commercial cannabis.
Excuse me, sir, I'm going to have to ask you to speak into that microphone for us.
Of course.
Thank you.
So this is an appeal of the Planning Commission's decision to deny 2016-1124, which is an appeal of the Planning Director's decision to deny 2016-404. A little bit of context, the subject parcel is a 5.93 acre parcel. It is located at 1820 Meadowview Road in West Point. This registration application was denied for not submitting a seller's permit by the September 7th deadline. According to County Code 17.95.165.n.5, it states that by September 7, 2016, a registrant with a pending application for registration shall provide verifiable documentation to the Planning Department demonstrating that the registrant has completed all of the following tasks for the medical cannabis cultivation operation located on the parcel to be registered. And one of those tasks is be in receipt of a state seller's permit pursuant to California Revenue and Tax Code 6001. Mr. Wong did not acquire a seller's permit until November 10th. And his appeal letters, he gives two reasons, one of which is he was ill-advised by a consultant firm, Fool's Gold. They, according to Mr. Wong, they did not submit all required documentation on his behalf. His second reason is that in November 2015, his mother passed away, and later on, regrettably, his father passed away in August of 2016, which is 8 months apart. However, it's the Planning Department's position that it is Mr. Wong's responsibility to submit all required documentation as per the urgency ordinance. That is what the Planning Commission felt as well. And while they sympathize with Mr. Wong's situation and his parents' passing, they concurred that the urgency ordinance is extremely clear and there's really no wiggle room for interpretation when it comes to the September 7th deadline in terms of a seller's permit.
Okay.
Any questions?
Any question from the board?
No, not at this time.
County Council, I would request an admonition of the evidence to be considered in this appeals hearing, a reminder for the board.
Just a reminder that the board can consider any evidence that is presented to it today any evidence that was presented to the Planning Department and any evidence that was presented during the Planning Commission hearings. Any new evidence that has not or was not considered during the appeal hearing at the Planning Commission level is not to be considered by this board. If evidence or new evidence is presented to this board, you have the option of referring it back to the Planning Commission to consider that new evidence. But new evidence is not to be considered at this hearing.
Thank you, Council. And now we'll hear from the appellant.
Good afternoon. Thank you for giving us the time to be heard on this matter. I'm used to being in front of judges, Your Honors Board.
Ma'am.
There's a little bit more detail to this.
Ma'am, could I ask, you are
Sorry, my name is Denise
representing,
Henderson.
he's your
and-
client, you're the attorney?
My name is Denise Henderson. I'm the
Thank you.
attorney of record.
Okay.
And this is Mr. Wong, who is the gentleman that made the application. Mr. Wong, there's a bit more detail than this. For instance, Mr. Wong filled out an application for the county in the proper time and provided all the documents that are necessary for that application. He did go to a place, and then I've advised the Planning Commission of this, a business in town entitled Fool's Gold that is claiming to assist people in applications for these grows, and they're not doing it properly. And personally, I think they're practicing law unlawfully, because you really have to give advice in putting these things together, and these businesses together properly, and to make sure that they follow all the laws, not just these, but all the laws. And so what they did is they gave him, told him what to do, what to provide. He did everything. Now, what he did not do was get the Board of Equalization seller's permit. Now, that's a pretty perfunctory thing, and the Board of Equalization, I don't know if they've ever denied anyone a seller's permit, because the whole point of that is to make sure that you let them know that you've got a business in California and you expect to be taxed and pay taxes on that business. So what happened here is that, and looking at some of the documents, and I don't know that the board has received the documents, because I continually was told to send it to the Planning Commission. And I understand, and I understand, and I want to have patience about the process, because I know this is difficult for all parties involved. This is a new thing for planning. It's a new thing for everyone here. It's a new thing for all of us, and we're dealing with about 5 different areas of law. So I'm looking at this, the Calaveras County Treasury Tax, the application for business license. Now that actually I don't think is required in the packet, but that is what Mr. Wong had filled out and included in his packet. And this was in June of 2016. June of 2016. Correct. The state's correct. So what I think possibly happened is, when you're talking about a tax, when in the list of the things in your ordinance, you have a list of the documents that are necessary to make an application. Now, there's a long list, and then later on in the document, it talks about the seller's permit. It's not very clear, but it is supposed to be the Board of Equalization. And they allow and ask for that to come later, or that it could be submitted later. I guess the point with the application is that, in what I'm reading, you're supposed to submit a complete application. That's what Mr. Wong believed he did. He submitted an application with a seller's permit. He had he spent up to $20,000 in fees, and having the ecological reports done, and having all of the things done that are proper to have a business. At the Planning Commission meeting, the Planning Commission didn't think they had authority to make a decision on this, because it was they didn't have any statute to rely on in such a situation where what the planner did was look at it. They saw that he didn't have the Board of Equalization number. They didn't see this application, which really isn't, it should be necessary in a packet, but it's not. But it is one of the taxing documents that should be filed when you run a business in a county. And they stopped looking at the complete application. So they stopped at that point. And in that complete application are all the documents that are necessary. All his fees, all what's more important is the watering, the monitoring watering, the notice of intent, the background. I did obtain the seller's permit as soon as I was retained on the case. And that, of course, we have a seller's permit. As to this point that he stopped business as soon as he was denied, there's been no business, no sales, nothing involved with his business. So there are no taxes, seller's taxes due, until his understanding was when he received approval by the county. Then he's going to go forward and work, have the permission to work and grow and do all the things that he can do. So the biological site assessment is in the packet that was sent to the planning committee. But they didn't get to any of that, and they didn't look at any of that, and I understand that when looking at it and saying, okay, there's not a seller's permit here, kick it out and send it back. But the purpose of that, in looking at other areas where you tax and you zone businesses, you don't just terminate the ability to have a business in Calaveras County when you have missed one technical thing that hasn't even become an issue yet because no business has taken place. Now, he's also has, you know, the background, and this is a $6,000 report. The other thing that we had at the meeting, the Planning Commission meeting, was that there was a gentleman there with a neighbor. And he came and he testified and said that originally they didn't want anything to do with any of these businesses. And he said after, it was about a year of working and seeing Mr. Wong and his employees, the people that worked there, and how he did business, they had all changed their minds about this business and about objecting to it. Because they saw that it was being put together respectfully. And personally, I prefer to support businesses that are going to be ecologically considerate, that are going to follow all laws, and that are going to pay all their taxes, and are going to be a benefit to the community. I believe this application was for a medicinal permit, and which wasn't mentioned here, and there are medicinal aspects to that. As far as the parents passing, Your Honor, excuse me, as far as his parents passing, this was a family that was very close. His parents lived with him and his wife and children as he lived with them all of his life. So he had lived with his parents his whole life. His mother passed as they said, 8 months before the father passed. So his mother passed, he began to take care of her. At that point, or shortly thereafter, he made that application in June of 2016. He made the application to this county. And things were going fairly well with the family. Now, it was in November 30th that his father passed. And at that point, and I know that anyone about our age understands that process of losing not just one parent but two. His sole attention was to his family and his parent. Now at that point, he believed that he had submitted a complete application, not only because he was told and advised by Fool's Gold, nice name, but that he had submitted all of the documents, and he had also obtained the county permit, the tax permit that you would normally get when you do business in a county, that I don't believe is listed in the stack of documents that's required in the application. But as soon as then he found out November 11th, he received a phone call, correct? October? I'm sorry, October 30th, was it? Received the letter indicating that there was a denial. Now, he had, between the time that his father passed, less than a month, where if he had been possibly even knowledgeable that he was missing a document, he would have taken care of that. When he became aware of it by the planning commission, or by the planner, it was too late. So that was where our problem was. It was too late to submit that, an easy correction, fairly easy correction. And so, of course, we did that, came to the board. A planner had already been out to the business and told him they thought that it would be fairly simple because it wasn't an egregious error, and that he had done everything else properly. We have not been able to communicate very well with the planning committee, and that makes sense because, of course, they're overwhelmed. But they truly indicated they did not think they had the ability to make a decision on this issue, because And if you look at the regs and look at everything, it says late in the packet that this one document is due September 7th of 2016. My suggestion would be that all documents are submitted at once. And when I put a business together like these, the first thing I do is I go to the Secretary of State and then I go to the BOE. But lay people miss these things. Now, what I'm asking is that, first of all, I think that I would hope that this is not just a way of jumping through hoops and not being forthright about what's been passed in both the state, and county, indicating that there is an opportunity to do business, particularly in the medicinal community, to do business in this industry. And what we want to show as an attorney and as representing people, want to show boards and the counties is that this can be a business. These can be businesses that can benefit the community. Now, in this case, you're just talking about a grow. So what do you want in that grow? You want to make sure that person's not putting anything nasty into the environment, that's not using the water incorrectly, that is not a nuisance, that doesn't smell, it doesn't have a bunch of dogs running around, you don't have razor wire. It's something that is an asset. Now, this is what he's trying to create. And in that, there are people and scientists that are working with CBD. And whether any of us have experienced it or not, the findings are that there are people in your community that benefit from this. And there are people that are not wealthy and can afford a lot of anything. And this is what they're using. Just
Counsel,
briefly,
let's get back to the issue, please.
yes, and my issue is that at this point, I don't believe this should have had to come this far, because the Planning Commission needs to understand that they can do some things at their hearings. That may speed the process through a bit. This was one of those things. One gentleman on that planning committee said, I understand, this is not, and he voted in favor of us. And the other gentleman said, I don't think we can even decide this, so let's send it on to the board. So Mr. Wong has done everything that he can do. My office has attempted to communicate with the planning committee, with the board if necessary, with whoever we had to not circumvent, but make things go faster so that you in your county can have the tax that he can give to you. This is why this is one of the reasons we're doing this. His investment and the promises that this county has made, and then to understand, and I don't know that you received the letter that I sent, or that's why I wanted to try to tell the story a bit, but this is a gentleman who had a very close family, and that loss of his parent did disturb a number of things, but it didn't disturb, he's also a business person. This will never happen in his life again, to lose two parents. And he made the mistake in giving you the county tax collector document, signed off on that, put that in the packet, and didn't get the BOE. And as I stated before, the Board of Equalization, at this point, I'm not saying no harm, no foul, but you've got someone in your community that has put a lot of time and energy into showing you that how it can be done properly. And don't waste that on a technicality, which is going to end up, unfortunately, in litigation, because if you look at your documents, it's a little unclear, and we are starting from scratch here in many ways. And I can point to further areas in the application that I think need to be pointed out. For instance, here on page, doesn't even have the page number, but it's in your ordinance, and it is under, under definitions, I'm under mandatory registration of medical cannabis cultivation sites, and it indicates the things that we're supposed to do with the planning department. Now, it says if you're a corporation, you have to go to the Secretary of State, okay? But it doesn't tell you anything about the BOE number until much later. And it is complex. Not that that part is complex, but the laws and the regs in this area are complex. The regulations for zoning and for city ordinances and building businesses are complex. Mr. Wong went to an outside person that did not advise him to get that Board of Equalization. They advised him somehow he got the county one. Now, do we throw away not only the services that have been done by people in this county, but what's been done by the planning department so far, and taking the application, you know, and is he going to be denied because we didn't get that until it was too late for him to fix it? We fixed it, and there have been no sales. But as soon as he's registered and able, he'd be looking at something like, it's an amazing amount of tax that this county's going to receive on medicinal permits. And I know that's not the only thing you're thinking of, but I think in the packet, and I don't know that you've all seen the packet that was submitted with all of the documents and all of the studies that were done that are required to have done, that Mr. Wong had done. And I would submit with that.
Thank you, Counsel.
Something else? Thank you.
This time, we have presentations by member of the public. Those should be limited to 5 minutes for each person.
Bill Wilson, District 1. To the best of my knowledge, a reseller's permit is required if you're selling retail. It's not required if you're selling wholesale. We can't sell retail under state law. We have to sell to dispensary or distributorship. Therefore, no cannabis cultivator should be collecting sales tax unless they're putting a manufactured finished product together, which isn't allowed under the UO. So how can you require that somebody have a reseller permit when they haven't got a business license, they haven't been approved by anybody? They've set up a date, a final date. There's no date for planning or the sheriff's department to finish that application or to inform them that there's any mistake other than just a straight rejection for a reseller permit. Now, if he's rejected here, does that mean that his state license is now in jeopardy and he can never grow marijuana because he didn't get a reseller permit that he has no use for? He's never going to file any taxes or pay any taxes on that unless he sells retail, right? Thank you.
Thank you, sir. Any other public comment?
She'll have an opportunity for rebuttal.
Just that Mr. Wong has had his background check done by the sheriff as well. That's another resource that's been spent by the county. And it was approved.
Thank you, Counsel. That information was brought up in the Planning Commission's hearing. That's correct.
Good, thank you.
All right.
So yes, it was approved.
Any further comments by the public? Any summation and rebuttal by the appellant? 15 minutes. Counsel, it was submitted? Understand?
I will submit it. Yes.
We'll have staff summation and rebuttal. Mr. Mauer?
We don't really have anything additional to add. Again, this is a standard requirement for all commercial cultivators. three items listed in section N5. The vast majority of other cultivators have received the seller's permit, submitted that to us. We felt that the time frame was very explicit in the code, and therefore felt we had really no other option other than to deny it. It was unfortunate given the circumstances, but it wasn't, we didn't feel that we had that kind of flexibility.
Thank you, Mr. Mauer. Do we have any rebuttal by the public? Hearing none, we'll go to board discussion. And I would elicit any comments from the Board of Supervisors. Anybody have any questions? No, I have a couple of issues. I would like to know, has their business license been obtained by the appellant? Yes. Okay. Has that been confirmed with our agency?
Business license hasn't been obtained, but a business license application for the county has been submitted, which is part of the September 7th requirements.
Has a seller's permit been obtained?
Yes, it has. She turned it in, or Ms. Henderson turned it in with her appeal to the Planning Commission,
Do you have a date on that?
November 10th, 2016.
November 10th?
Mhm.
And I have a question for Mr. Mauer, possibly legal counsel for planning on this issue. The issue of the sales tax resale permit, is that required with the application or when you make sales? Part one. Part two, is in fact the sales of cannabis, medical cannabis, retail or wholesale, does it apply?
I don't know the answers to those questions. The only thing I can state is that it is a requirement of our code to submit that, and the vast majority of sellers, growers, of cultivators have submitted the seller's permit.
And that is required by
By
our
county
ordinance,
code, our ordinance
and that's
17.
uniformly enforced throughout all the applications.
Yes, it is.
Any further questions by the board? Any further questions by the appellant or counsel?
Yes, did the planning commission do anything further than just deny it, looking at the fact that there wasn't a seller's permit? Did they look at any other documents?
That was the only reason that we stated as reason for denial.
That's your question?
And is it true that the planning commission did not feel that they had the jurisdiction and they needed the board of supervisors to make this decision for them? That was in the planning, early in the planning. I don't know what kind of record was made, but Mr. Contreras was not there. Mr. Mauer was, I believe.
The planning commission has the authority to uphold the decision by the planning director or approve the appeal and reverse. They chose to uphold the planning director's denial. They did not feel that they, in their statements, that they had the authority to overrule a provision of the code that was, I'm not sure exact wording, but it was very plain text that this was required to be submitted as of September 7th. They felt that I think, as I recall, they made a statement that that would be up to the board if the board wanted to somehow come up with an exception to the rules that the board established.
In other planning, I'm not sure I'm speaking directly to the board or to planning commissions, but in other zoning and business applications, is one denied when you are missing a single document, or is the denial normally in a situation where there's fraud or there's something much more than, and in this case, not missing a document because he had something that he thought was correct. Looking at ABC, the alcohol control boards that are utilized by this county, I think in looking at some of those, most of those, they're given opportunities to provide the document and they don't lose the right to running a business. Isn't that correct?
Submitted by parties?
The urgency ordinance is somewhat unique in that it was, in a way, addressing the retroactive application of existing growers. And there were some things were established that this is what was required on May 10th, that you had to have established your cultivation site. There was a deadline for submitting the paperwork to the county on June 30th, and then a subsequent deadline for additional items that were required, knowing that it would take longer than approximately a month and a half necessary to acquire that from some state agencies. So the county established a 90-day time frame to provide those other additional things: the business license, the seller's permit, and the registration with the Board of Equalization. It typically, in other applications where you're looking at something, let's say a parcel map, where you don't get to move forward until you actually have the permit in hand, we will work with the applicant and say, well, gee, we're missing this item. But this was an urgency ordinance. It was intended to freeze cultivation until we had permanent regulations in place. And these were the requirements in order to establish that. The comment, I'd like to refer to another comment. While this was the only reason that the application was denied, at the time it was denied, we hadn't gone through our complete review of it, but this one came up as we were reviewing all of the applications for compliance with the September 7th deadline. This popped up because we didn't have it, and therefore was not in that. We have yet to have an inspection made of the site, so I cannot say one way or the other whether or not it would pass the inspection. It may not. We don't know because we haven't had the inspection yet.
Isn't that part of the application process that you're applying for an inspection? And if one of the documents, what I just heard, one of the documents was missing, they would have called and said, can we get that document? But in this case, they did not allow him to provide, in this case, you didn't allow Mr. Wong to provide that document, even though it was a very simple document to obtain, conversely with the other documents that he did obtain. And it's true that he did meet all the other deadlines as well, isn't that correct?
Okay. Council and staff, is there any other comments before I close the hearing?
No.
Board Chair, I would like just to remind the board that this appeal hearing, the board is tasked with interpreting our code. So when the board adopted the urgency ordinance, our board adopted our local laws. And so whenever an issue comes up for interpretation of our local laws, our ordinances, it's tasked with the board to interpret. So when it is appealed, when a planning director's decision is appealed to the planning commission, when the planning commission denies that appeal, it can be appealed up to this board. In this situation, the main issue that this board needs to be aware of is how you interpret the provisions of the urgency ordinance as it's written. Under section, as Mr. Maurer indicated, under section 1795165, I just want to make sure that the board is aware the language of the urgency ordinance under N5, A, B, and C says that by September 7th, 2016, a registrant with a pending application for registration shall provide verifiable documentation to the planning department demonstrating that the registrant has completed all of the following tasks for the medical cannabis cultivation operation located on the parcel to be registered. A, receipt of a current valid business license pursuant to 5.04 of the Calaveras County Code. That is a standard business license, which appears to be the license that the attorney identified as something that the applicant had obtained. B is receipt of a state seller's permit pursuant to California Revenue and Tax Code 6001. And C, an active registration as a business entity with the California Secretary of State and Board of Equalization. So what's before this board is interpreting the language of that code provision and whether the facts in front of this board are sufficient that you believe that this applicant or this appellant meets the county code as you interpret it, whether there is other factors that you are considering that would allow for that time frame to be extended, or how you interpret the language of that specific section of the urgency ordinance.
Thank you, Counsel. Is this part of the appeals hearing, or can we respond to it in board discussion, Counsel? I feel we should be able to have this information during board discussion, and I'm going to close the appeals hearing.
That is in the discretion of the board chair. If the board chair is inclined to allow the appellant's attorney to respond to just my comment, that is in the discretion of the chair, considering all of the summation and the rebuttals have already gone through, but certainly in the board chair's discretion, you can allow for the additional comment if that's what the board.
I would actually rule in that manner. So I'm going to close the hearing. Counsel, did you come up, you want to respond to?
I'm sorry, I thought you denied that. Just briefly,
Come up to the podium.
the law also, I believe your duty is also to evaluate what's not in that document as well. Oftentimes when ordinances are written, there isn't anything, and that was what the planning committee had a problem with. There wasn't anything, if there was some error or some problem with the individual that should be considered by a committee that isn't fraud, it isn't intentional withholding of evidence, of documents. So I think, yes, you have the duty to evaluate what that is, what your ordinance says, but also what it doesn't say and what it might need to say in the future to clarify this for the planning committee.
Thank you, Counsel. Bring it back to the board for discussion. Questions? Supervisor Tofinelli?
No, I don't have no.
Supervisor? Sir. Garamendi? Supervisor Clapp?
None.
Supervisor Mills?
No questions.
I have no questions. I would entertain a motion to uphold the decision of the Planning Commission matter in this appeal. And I would ask that, Madam Clerk, could you read exactly what the board would be reviewing as a motion request? In other words, maybe council could assist, what would indicate upholding this appeal? Would it be an aye vote or a no vote? I want to clarify
I
that.
would support the denial.
Correct.
So an aye vote would support the denial as
voted
agendized.
In favor of the item as agendized, it would be to uphold the planning commission's denial of the appeal of the planning director's denial. So this board would be upholding, with an affirmative vote, would be upholding the denial of the appeal.
Thank you, Madam Clerk. With that information, I'll entertain a motion.
Board chair,
Oh, I'm sorry.
can we take a brief, 2-minute recess?
Sure.
Thank you.
Be back in 5 minutes, folks. Board, I would entertain a motion regarding item number 27, the appeals from the appellant, Mr. Wong.
I would move to deny the appeal and uphold the Planning Commission's decision.
Have a motion by Supervisor Mills to uphold the Planning Commission's decision.
Second?
Second by Supervisor Garamendi. Any public comment? I'll bring it back to the board. Indicate your vote by saying aye for the affirmative, no for against the motion. All in favor? Say aye. Indicate by saying aye.
Aye.
Aye. All opposed? Hearing none, motion carries 5-0 unanimous.
Item 28 is from the planning department pursuant to Government Code Section 65858, extends the applicability of Chapter 17.95 of the Calaveras County Code, an urgency ordinance regulating medical cannabis cultivation and commerce for a period not to exceed 1 year.
Ladies and gentlemen, before we start, I'd like to remind everybody this is going to be a very involved discussion. And I'd like to remind everybody to stay on topic with the agendized item. It's going to be very important that we get all the most accurate information disseminated by all positions regarding this issue. With that, Mr. Mauer.
Good afternoon, Peter Mauer, Planning Director. Before I get started, we had a bit of a glitch with our electronic agenda item, and we lost some of the documents that were submitted. And so I have passed out a copy of the proposed resolution to each of you, as well as there are copies of it on the podium for the public. This is essentially a follow-up to our discussion that we had on the 31st, 2 weeks ago. Take a break, folks, and we'll get copies.
Well, that's good. Maybe you want me to read it while we're...
Sure, yeah. Okay.
Okay. The resolution that's being picked up on the podium reads as follows. Resolution extending the applicability of Chapter 17.95 of the Calaveras County Code, an urgency ordinance regulating medical cannabis cultivation and commerce for a period not to exceed 1 year. Whereas on May 10, 2016, the Board of Supervisors adopted the addition of Chapter 17.95 of the Calaveras County Code, an urgency ordinance regulating medical cannabis cultivation and commerce within the county. And whereas the Board made findings within 17.95.120 describing, among other things, the immediate health, safety, and welfare need to regulate medical cannabis cultivation and commerce pending completion of an environmental impact report for a permanent ordinance addressing the issue. And whereas when a zoning ordinance is adopted as an urgency measure to protect the public health, safety, and welfare pending further study, Government Code Section 65858 requires that the ordinance initially go into effect for a period not to exceed 45 days. And whereas if 45 days is an inadequate period of time to adequately study a permanent ordinance, Government Code Section 65858 allows for an urgency zoning ordinance to be extended twice by the Board of Supervisors before it either expires as a matter of law or is replaced by a permanent ordinance. And whereas the county extended the urgency ordinance on June 21st, 2016 to February 14th, 2017. And whereas the conditions remain that require immediate regulation of medical cannabis cultivation and commerce to protect the public health, safety, and welfare. And whereas an extension will be needed to maintain the urgency ordinance in place until the EIR is completed. And whereas a subsequent extension of an urgency ordinance under Government Code Section 65858 may operate for a period of no more than 1 year after the extension is granted. And whereas the county published notice on February 3rd, 2017, pursuant to Government Code Section 65090, and held a public hearing pursuant to Government Code Section 65858. Now, therefore, be it resolved that the Calaveras County Board of Supervisors finds and declares that the foregoing recitals are true and correct, and further finds and incorporates hereto all findings set out in Section 17-95-120 of the County Code. Be it further resolved that the Calaveras County Board of Supervisors hereby extends urgency ordinance number 2016-0510-3069, which was passed on May 10th, 2016, and was extended on June 21st, 2016 to February 14th, 2017 for a period of no more than 1 year.
Thank you, Madam Clerk. Mr. Mauer.
So as we discussed 2 weeks ago, we looked at a variety of options regarding the continued regulation of cannabis cultivation in the county. At that time, the board gave some direction to staff including to prepare a ban ordinance that would be gone through the normal process, as well as the previous determination by the board to place the initiative on the ballot for May 2nd. So we've got two parallel things going with that. In the meantime, the urgency ordinance expires today if not acted upon, and it was the consensus of the majority of the board that we would bring back a resolution to extend that ordinance. I think there was quite a bit of discussion as to the length of time, how long it should be extended. The extension of the ordinance would leave the existing regulations in place until a permanent ordinance is adopted, whether it be a ban or regulation, or the citizens' initiative passes that would then enact the ban. Once a new ordinance becomes effective, which would be either 30 days after the adoption of an ordinance or immediately upon passage of the initiative, then the urgency ordinance would have no force and effect. We are recommending that you extend it for the full length of time that is allowed under law, not because we think we'll need that amount of time, but you just never know what's going to happen. There could be all kinds of contingent circumstances that may delay us beyond what we expect to happen, and that just gives us the additional insurance policy, if you will, to have something in place rather than go back to the lack of any regulation, which led to the problems identified by the prior board to adopt the urgency ordinance. The lack of any regulation led to the sort of the free-for-all of what was occurring a year ago at this point in time. And while it may not be, certainly not perfect in everyone's eyes, or probably in anyone's eyes, having some regulation is better than no regulation whatsoever. So with that, we are recommending that you adopt the resolution, extend the ordinance for another year until such time as we adopt something else permanently in its place. I would like to turn it over to the interim CAO, who wanted to talk a little bit about some of the financial ramifications of where we are right now. Another one of the directions of the board was to report back on some of the finances of the ordinance. So with that, I'll turn it over to Mr. Lopez.
If I may, Mr. Chairman, as Peter's already indicated at the last meeting on this subject, you asked that I bring back some information regarding the expenditures. Since the adoption of the urgency ordinance and the collection of the medical cannabis cultivation fee, a number of departments have charged staff costs, certain capital assets, professional services, as well as services and supplies for the implementation and enforcement of the program. The departments that have utilized more than $10,000 for the cannabis fund as of February 6th of this year, and the corresponding charges made by those departments I'm going to go through those just for your information. The first department is information technology, has used $114,727. County Council has utilized $99,400. Geographic Information Systems, $40,146. The Agriculture Commission, $27,121. Planning, $193,172. Environmental Health, $24,573. Building Department has utilized $168,741. And the Sheriff's Office has utilized $723,880. There have been a number of other departments that have charged very minor amounts, relatively minor amounts, all of them under $10,000, most in the several hundred to low thousand. For the sake of interest, I didn't itemize those. In addition to the activities associated with the implementation of the UO and the commensurate charges that I just mentioned, some departments indicated that they have been impacted in their ability to conduct normal day-to-day operations. Although these impacts are difficult to assess and to quantify, they clearly seem to be having an effect on departments. This is particularly true in the cases of the law enforcement departments. For example, and you've heard the sheriff indicate that as a direct result of his work on UO issues, he has had to become involved with law enforcement criminal activities that are indirectly related to the UO, but the UO does not provide for reimbursement in those instances. Nevertheless, when staff is working those indirect criminal activities, they are not otherwise available for routine duties, although thereby incurring costs which do affect the sheriff's operations. Likewise, the district attorneys indicated that her office has assisted other law enforcement agencies with marijuana-related crime reports that might not otherwise be directly UO-related, but because of the complexities and the interconnected nature of some marijuana grows, it is extremely difficult for that office to definitively determine whether or not those activities stem from the UO or other unregulated grows. And lastly, the development of the program itself was a significant task. Once the program was established and the funds were programmed, there was an urgency by staff to recruit appropriate staff for the various departments, to train new personnel, to conduct application reviews, obtain new vehicles and other equipment, to analyze new data, and to communicate with the applicants and the community at large regarding the status of the various applications. All those activities did affect the normal operations of numerous county departments during that period of time. That's all I have, Mr. Chairman.
Thank you. Mr. Mauer, further comments?
I have nothing else unless you have any questions of me.
Okay, comments from the board? Questions from the board? Questions of staff? This time we'll open it up to public discussion. You will have 3 minutes.
I think there are some
I'm
other
sorry.
departments that may want to.
Captain, I apologize. This will be as part of the staff presentation, not limited to time limit.
Good afternoon, Jim Aceto. I'm a captain with the Sheriff's Office. I'm going to be going over the contents of a memo which will be displayed on the projector, and then you're all going to have a copy of the memo. There's some statistics and information within the memo that the board had requested at a previous meeting. So I'm going to provide kind of a broad overview of what's included in the memo, and then the sheriff will speak to you and conclude with some of the comments that are going to be more political in nature. Just some background over the urgency ordinance. The little graph you see there is the number of staff that was allocated to the sheriff's office from the marijuana urgency ordinance. You can see we were allocated 1 sergeant's position, and then on the far right-hand column, you can see that position was filled. We were allocated 6 deputy sheriff positions. You can see at this point in time, 2 of those were filled. Down below, we have a sheriff services technician, 2 full-time. 2 of those were allocated. 2 of those have been filled. And then lastly, on the bottom, we have extra hire sheriff services technicians. 4 of those were allocated, and currently 2 of those have been filled. Jumping back up to the deputy sheriff section, the second one down, when you ask yourself why are not all those positions filled, we would have to fill those positions at the detriment of patrol staff. We would actually have to pull people off of the street who are covering a beat, who are providing service to your constituents on a 24-hour basis in order to fill those marijuana-related positions. We do plan to do that in the very near future. We've recently hired quite a bit of staff, and they're making their way through the field training program. On the bottom of that paragraph, we're going to talk about enforcement hours. You'll see that with relation to marijuana enforcement, registration, inspection sub-projects, we basically spent about 6,215 hours working on marijuana. Can you jump to the next slide, please? So that's just a graph breakdown. Below, you'll notice some of our sub-budget units, and specifically you can see the amount we have spent on marijuana with a total that the county administrative officer noted. Roughly 78% of the amount of time we've spent on marijuana since the urgency ordinance had occurred. Next slide. sampling of some of the expenses. Can you slide back down a little bit? Next is there's a sampling of some of the expenses. You can see the clothing. The clothing seems high. Keep in mind when we go out to do a large marijuana eradication or a large dangerous investigation, it's not just the sergeant and the 2 deputies assigned to marijuana that go. Our SWAT team will go, other detectives will go, members of the Sheriff's Administration will attend. So some of that clothing is spread out amongst a lot more than just a couple of staff members. We actually store that clothing and check it in and out to those that work marijuana. But there's an expenditure breakdown for you to review either now or at a later date. The costs that Mr. Lopez mentioned, our total enforcement costs to this point from July 1st, 2006 through January, so this is just a mid-year point, $212,000 of that was related to salaries and benefits. Other costs, which were noted above, is roughly $480,000 for a total of $692,000. Again, that was broken down in a graph for those of you that are interested or find graphs more visually friendly. I want to stop at this particular slide. What those enforcement activities include, when we show up to conduct an enforcement action, that's not necessarily when the clock starts. There's a lot of planning that goes into that, training the staff. We obviously have responses to incidents based upon our patrol staff as well as our investigators. The investigations are incredibly time-consuming. And I think when most people think of financial impacts to law enforcement, they think the clock starts or the money starts once the crime or the problem occurs, when in reality, there's a lot of pre-planning and a lot of stuff that goes in before we ever really leave the office, and there's a lot of costs associated with that. There's also a lot of time. So when you hear people want to know why it takes so long to conduct an investigation, why does it take so long to respond to a particular location where there's marijuana involved or some other crime, we don't just saddle up real quick and run out to a place unless there's a impending emergency. We actually study who's there, what's going on there. We look at backgrounds of people who are known to be there. There's other investigative methods that go on that I won't necessarily get into. But there's a lot of work and a lot of expense that goes into a case before we ever leave the office. So I want to make sure the board is aware of that. Numbers of incidents relating to marijuana. Our incidents are managed through our records information management system. And again, utilizing that same time period, we had 268 incidents relating to marijuana. The average time it took to complete one of those incidents is roughly 2.5 hours. Now, some of them are obviously handled in a very short period of time. In one particular case, we were there for about 48 hours straight, maybe a little bit longer. So sometimes we have to actually secure a location and sit on it for a period of time while we're either waiting for a search warrant, or in other cases, it takes us 2 days to actually process marijuana. There's that much marijuana, and it's that difficult. There's a lot of heavy labor involved in eradicating some of the problematic grows. The following are some sample type incidents. I don't want you to necessarily focus on the numbers to the right of that column, but these are crimes that have been directly related to marijuana in the last 6 months. These are crimes and cases that are directly related to people we believe arrived as a result of either the urgency ordinance or the message that Calaveras County was open for marijuana cultivation and production. The illegal marijuana cultivation shouldn't surprise anyone, neither should the possession of methamphetamine. We've had a perjury case, obviously driving on a suspended license, robberies, assault with deadly weapon other than a gun, with a gun. We've had a couple of rape cases reported. We've had some other sexual assault cases, domestic violence, violations of parole, elder abuse, brandishing a weapon, terrorist threats, arson, burglary, grand theft, cruelty to animals, and attempted murder. Next slide. So in summary, if you want to look at the amount of money, the Sheriff's Office essentially was allocated about roughly $1.3 million of marijuana funds. We spent about $754,000 or 58% for salaries and benefits, and another $556,000 for supplies, services, and equipment. We've also are encumbering some funds because we don't know what we're going to be facing this next year. Crime and issues related to marijuana don't stay static. Sometimes we have to adjust on the fly, depending on what problems are in a particular or given year. And I want to emphasize that all of this information was thus far, meaning as of January, and things do tend to change over time. To kind of conclude my statements, after listening to the board talk on this issue for quite a while, but more importantly, probably the last meeting, it was clear several board members had some questions. So before I came here today, I put together some notes specific to if I was a board member, what would I want to know as it relates to the urgency ordinance. The first question would probably be, is the ordinance working well? Unequivocally, that answer is no, it is not working well. It's not working well for the reasons that I've already spoken to the board about, as has the sheriff, and I think you've heard from other county staff, but I'm going to stick with the sheriff's office, is unequivocally not working well. I do not believe it was a well-drafted ordinance, and I don't believe operationally that it's very, very realistic, especially considering the tasks you've given the sheriff's office and the language involved in the ordinance. Secondly, is discontinuing the urgency ordinance a problem for the sheriff's office? Meaning if you kill the urgency ordinance, and the answer to that is yes, it is a problem. It is a problem because we have created a monster in this county, and we need to address the monster, and there needs to be some funding to support us to address the issue, regardless of which decision you make, whether you decide to ban it or whether you decide to allow cultivation to continue. And lastly, the third question is the ordinance attracting violent crime? And I talked to you about that last. And importantly, I think the board needs to be aware of this. Yes, it is attracting violent crime, and the associated costs related to that violent crime cannot be billed back to the urgency ordinance, not as it stands today. Thank you.
Thank you, Captain.
I have a question of it.
Captain, would you prefer questions on your presentation or after the sheriff makes the presentation from the board?
I'll let the sheriff speak, and you can call whichever one of us up at a time.
Good afternoon. As I've stated before, the urgency ordinance has been very problematic for the sheriff's department. It was in its conception, and because of the fact of us being understaffed. The fact that we didn't have people in place. We had no infrastructure to handle what we ended up having. Originally, when this was brought to the board, we, as I did, expected to see 200 growers, and we ended up with quite a bit more. I don't think that we thought that we were going to get the amount of illegal growers that we ended up getting. So, as a whole, it's been a problem all the way around. The issue that we have now is to continue this emergency ordinance. I had somebody who sent a pretty nasty email about me, stating that don't do anything for the sheriff. He doesn't know what he's talking about. He wants to extend the urgency ordinance. Let me explain something to you that if you don't extend the urgency ordinance. Number one, you have the option, you as being the board, to put your own urgency ordinance or your own ban in place or regulations in place. That's going to take some time. We have the voters initiative that's coming up May 2nd. The concern that I have, and this is the concern for the safety of this community, is that if we don't have that urgency ordinance in place and that citizen ban fails, and you cannot put something in place immediately, you open this county up to a shitstorm. Bottom line, it's going to cause problems. If you extend that ordinance for the year time frame that is allowed by law, which planning and most department heads have requested, if you put something in place prior to that, so be it. The urgency ordinance goes away. If the citizens initiative comes into play on May 2nd, the urgency ordinance goes away. So 6 months or 6 years, it doesn't matter. A year is what it should be by law. Because if the citizens initiative does not pass, and you can't get something in place, you have to protect this county. That is your job, that is my job. And I can't do it without the urgency ordinance because of what it's going to open this county up to if we don't have something. So unless you have something in place before the end of today, you very seriously need to extend this ordinance, or it could, big word could, cause problems. That's it in a nutshell. It's very simple. In my eyes. Maybe my eyes are looking left where they should be looking right. I don't know. But I don't see a way around this. The ordinance being extended doesn't change what you folks or the citizens are going to do. It doesn't hurt anything to extend it for the full year. Any questions?
Any questions of the sheriff?
Well, maybe the sheriff would be the correct one to ask. Certainly do appreciate the time that's been put into this by Captain Macedo and the memorandum. I think that's very helpful. But I would like to ask, because it was brought up, what do you feel, it's not just a rough number, what you feel that the indirect criminal costs have been to your department? Because those are actually reductions of service in the rest of the community. Would you have to pull that from your budget?
I don't know that I can give you that. We would have to go back, and I think that's detailed in that letter that was given to you, that we would have to go back and individually go through everybody's time cards to see exactly what they did and how much time they spent on that. The problem is when we have something that happens out in the world, everybody goes.
Right.
And then they may break off because they're not needed anymore. So it's very difficult to give you an exact number. When this program was implemented, I wanted to have a separate line item for my budget for marijuana. It was brought to us as a project. So it's harder for me to track those hours in that aspect. So to give you an exact number, it's very, very difficult to do. It would take a lot of man hours to figure all that out, is the bottom line.
I think it can be interpolated, though, over time.
To do it, to go back now?
Yeah, to go back, forensically look at it. But that's for something in the, not right now, but in the future at some point, we may want to have that look as to see what those unintended consequences were.
So after you made that request, we sat down and discussed what the sheriff was talking about. Can you hear me okay?
Yes, sir.
I can hear you, Captain.
And when the sheriff says that there's a project, the problem is, and this is something we hope to address during the budget year with the CAO's office, there's a definitive line within our patrol budget that's marijuana enforcement. Instead of it being its own budget out in right field, so to speak, where we bill directly into and out of it, it was lodged in. When it was lodged into the patrol budget, that causes the auditing process to become much more complicated. In addition, since we do not have enough staff to work marijuana, we have to pull staff from marine safety, narcotics, patrol, court services. All these people have to be pulled out, work marijuana for a certain number of days. There needs to be a billing and accounting to those people, and then they go back to their home, which is in a completely different budget unit. So if you ever wonder why we have a business manager, it's because of that bureaucratic nonsense right there.
Sounds like the state's budget.
But what I can tell you, Supervisor Mills, what we did discuss, and we just couldn't get it done because we're currently working on 2 other big auditing type projects, we could grab 3 or 5 big cases, and emphasize big, just to demonstrate how expensive those were to our organization. I'd hope to have that done today. We just ran out of time.
No, I appreciate whatever effort that you can do towards just trying to be sure that we understand those indirect costs, because that is going to be something we're going to need to discuss in the future budgets.
Agreed.
Okay. Thank you.
Any other supervisor have questions of the captain or the sheriff?
I just have a quick question, if that's all right.
Sure.
Sheriff, thank you very much for the presentation. Captain Macedo, thank you as well. I asked this on the 31st, just wanted to double check. We discussed that if you had all the resources you needed, that we could bring this under control in a few years. Is that still the case?
Yeah, if I had the personnel on staff, then absolutely, within 3 to 4 years, we could get a handle on this. And the reason I say 3 to 4 years is because it takes time to get people hired to put them in place. If it was a perfect world and I had everybody on staff right now, we wouldn't be having the issue that we're having. So absolutely, it can be handled. And the thing you got to understand is that I hate to play Jerry Maguire on you, because whether you ban it or whether it needs to be regulated, you have to show me the money. I need to be able to put people in place to either ban it or regulate it. The costs are indifferent because these people are not going to go away. When I say these people, the illegal growers are not going to go away. They've been here. We've talked about that. Mr. Edson talked about that when he brought it up originally. They've been here. There is a lot more now than there ever was. Don't mistake that. There are a lot of people from out of the area that were not here. I have somebody from Maine who is trying to get registered, lives in Maine, but owns property in Calaveras County to grow medicinal marijuana. So there's a problem there. Now, if you go to Prop 64, and I don't want to get off topic too much, but if you go to Prop 64, the new commercial recreational growing, they have to reside in the state of California in order to get a license to grow. So for the county to put stuff like that in place in a regulation that'll work for the county, that's there. Yeah, absolutely.
We are going to need some help from the state as well. The sheriff has been working diligently with the state Department of Justice and the FBI because our backgrounds, they almost shouldn't be called a background. They're terrible. They're problematic because of the type of background we can run when it relates to employment. It minimizes the amount of looking we can do. So there's, we've mentioned this before the previous board, but right now we are prohibited from running growers interstate. So if you have somebody who applies, who has a criminal history out of state, we are prohibited from looking into that right now. That's just an example. There are several other prohibitions that are weak, in my opinion, very weak, and then and we're going to need state and federal help. It hasn't quite caught up with California law in order to be able to run a thorough, full background on folks. So to answer your question, can the county, given the staff, can we take care of business? We can't, but we're going to need some help in some of those non-traditional areas such as backgrounds.
Of course.
And we have that language already in place to go into a final draft ordinance if that's the direction you folks decide to go. So everything is in place, it's just a matter of implementing it and again, depending on what you folks do.
Supervisor Tofinelli?
Yeah, Sheriff, how many open positions that are funded that you have right now on the books that you're carrying?
For total or for just marijuana?
Total.
I believe right now we're at, with the 4 for the marijuana, I think I'm at 11, right? I think
So
it's
it's
10
excluding corrections, just excluding.
This is just patrol staff,
Patrol.
which we would use for the marijuana. I believe it's 9. Is it 9?
You have 9 open positions that
9
you're
open
carrying
positions,
right now.
Just sworn.
Dispatcher, not jail.
Right, and that doesn't count the 8 or the 6 frozen positions that we have that are in the parking lot.
Okay. All right.
Got your attention, didn't it?
Frozen positions in the parking lot.
Those are positions that, when we went back to 2008, and as the economy started to fall, those were positions that we were not able to backfill, and they are not funded by the sheriff, or not funded right now, so we would have to come back to the board to request those positions back. They're not even on the books, but those are positions that we used to have.
All right. Thank you, Sheriff. Any questions of the sheriff or the captain? I have one question. Maybe the captain can answer this. I kind of a vague question. Back on page 4, the following are sample incident cases types where we went down a list of violations and laws. Do we have any idea which of these cases are attributed to the registered growers versus the non-registered growers?
No, it's not differentiated.
Okay. Thank you. Any other staff presentation?
Good afternoon, Barbara Uke, District Attorney. I apologize if my foot fell asleep trying to up here. Okay. First of all, I want to thank you all for acknowledging that this is not a land use issue only. It is a much broader issue than that. Last year at this time, we were repeatedly told that this is a land use issue and had nothing to do with crime. So I really appreciate you taking a broader perspective and realizing that it is not so narrow as it was approached last year. During the study session, a board member asked what my position was on the urgency ordinance. I think it was Supervisor Garamendi, if I recall. And another board member asked what our impacts were. And so I want to deal with the impacts first. Interim CAO emailed me asking me, well, what are your impacts of the urgency ordinance? And I emailed back, well, which way are you asking? Are you asking about the fees? Because that's a really easy question to answer. And unfortunately, it was the other way around. It was the broader impacts. So to be very clear, in case you were unaware, my office does not receive any of the registration fee money. The registration fee money is very narrow in scope and very narrow in its permitted uses due to Prop 26. So my office would be considered peripheral in nature. We deal with the crime that occurs, and if it's not specifically the misdemeanor that is attached to the ordinance, my office is not covered. And and I never asked for fee money. It's not something that I want. It does create kind of a conflict. Prosecutors are held to a different standard than other attorneys. We can't be paid by case. Our salaries can't be determined on how many cases we file, because that creates a conflict. We have to seek justice, not funding. So I'm fine with that. And so when I mention the fees, I want you to appreciate that perspective and where I'm coming from on that. With respect to workload, that is a much more complicated question, and I did have some additional exchanges with Mr. Lopez about that, because I can't discuss my cases in public, and I'm not going to do that just to make points or to try to impress upon you how much work we're doing. It's just not worth it to jeopardize any of our cases. But I can say that our workload is a subset of what the Sheriff's Office does. Sometimes we are involved on the front end. For instance, whenever they do a search warrant, my office is very deeply involved. We like to make sure that they are going to withstand legal scrutiny. My office works very closely with the Sheriff's Office in reviewing all those documents. Sometimes it takes hours and hours and hours and hours of work. So for every search warrant they did, you can, I think pretty much all of them, just know that my office was there reviewing those search warrants after hours, at home, 2 o'clock in the morning, whatever it was, we were there, although you don't necessarily see it. For the work that gets followed up on, my office is also there to support. At a time, I did have 2 investigators. I'm down to 1. My investigators did help out in some of the frontline investigations when they needed it. But we also deal with other agencies, not just the Sheriff's Office. We also deal with whatever increased caseload Angels Camp might have. And certainly we've had some cases go through Angels Camp, whatever the CHP is dealing with, whatever CAL FIRE is dealing with, whatever Fish and Wildlife is dealing with. Those cases ultimately come to the DA's office. We are very fortunate that we've had the assistance of CDAA, that is the California District Attorneys Association. They have an environmental circuit prosecutor. She's taken about 30 cases for us that we would not be able to take otherwise. But that is, again, a peripheral result of the urgency ordinance. But we're very fortunate to have that resource. They haven't told me to stop sending them cases, and I'll probably keep doing that until they tell me to stop, but I think we're getting real close on the tipping point, because we do share that resource with 7 other rural counties. I don't know if Supervisor Oliveira will remember, I think Mr. Mills will remember, approximately a year ago, I was telling this board that my office was already overloaded. Our caseload had increased at that time. I have asked for additional resources to try to be a full partner in regulating or supporting or clamping down on the industry. I did have a plan. I've articulated that plan and what I think it would take for my office. I don't want to sound like a broken record. I feel like that at this point. It would take a unit of at least 4 people. I've set it forth in my preliminary budget memo last year. I came before the board during final budget and asked for it. I've been denied each time because it's expensive. It's expensive to invest in some infrastructure to deal with this problem. It is something new. It's a new venture that you want to try to get a hold of. Well, that takes an investment. And if you think that this industry is something that will be beneficial, well, it should be worth the investment. If you think that this is something the community needs to clamp down on it, then it also should be worth the investment. But we haven't gotten that funding in order to go down that road. There are a lot of things that we could be doing that we can't be doing. There are a lot of regulations and laws already on the books, but they're no good unless you have the ability to enforce them, and we just don't. So turning back to the urgency ordinance, some of you should know that I was not a fan of the urgency ordinance as drafted. I felt it was deeply flawed. I do think it actually made the problem worse than it needed to be made. But we need to look at what we have today. And we really need to take a step back, and we can't change what happened in the past. We need to look at what we have today, especially with the impacts that we've seen. The spotlight that was shown on our desperate lack of infrastructure. And 64, we can't ignore that 64 did pass. And we have to think, what are some predictable consequences of letting the urgency ordinance sunset? And maybe, what are some unintended consequences to that decision? And so while I am no fan of the urgency ordinance as drafted, I think we need to really look at what would happen one way or the other. And I think it's really important to understand that the MMPA and 215 are still here. The MMPA does not go away, at least until 2018. So without the urgency ordinance, we kind of open up the window. Okay, and so that's a very predictable consequence. And I would think that if you are in favor of a ban, or assuming the ban's going to pass, you want to consider that consequence to having that window open, even if it is for a short period of time. Okay, so what you also have to remember is that many of the people who were here growing before, they were MMPA grows. Then they got the right, because of the urgency ordinance, to grow commercially out in the open. If you close that, they're not necessarily going to go away. Now, some may, because they want to go to places where they have a future with their state license. But for the meantime, there is absolutely no incentive to go away. So if you were thinking we should get rid of the urgency ordinance because it's all going to go away, I don't think that's going to happen. It's just not going to happen. There is no incentive to happen, and for that to happen. Like I said, maybe some will, because they're thinking down the road a year or two. But you could end up with an influx, because people could come here to grow under the MMPA, because you've opened it up again. So I think, so those need to be considered as some predictable consequences, or maybe some unintended consequences of the decision. And the problem with letting the UO sunset is the return of fees and what it's going to impact, and how that's going to impact the departments that have really spent a lot of time in trying to make some headway on it. Now, I don't for a second think it's enough headway. I think that, like I said, the urgency ordinance is deeply flawed, and we did not have the infrastructure in place to go down this road, but we did, and here we are, and we need to look at what this road is. I don't get any money out of the urgency ordinance. It actually really does not matter to my department, but it does matter to the Sheriff's Office, Code Enforcement, County Council, Planning, and so I think that the bottom line is that letting it sunset is not really going to make anything better, but it could make things worse. It could make things marginally worse, and so that should be the consideration. So keeping it in place until it's replaced either by a voter ban or by board action, then the code compliance officers and the sheriff's office can continue to make whatever headway they can. The county council can continue to bring administrative actions where appropriate. And my bottom line on that is the urgency ordinance is not enough, but at least it's something.
Thank you, Jessica, for turning out.
I have a question.
Supervisor Platt of the DA?
Yeah.
Okay.
When you're in court, are a lot of the defendants being defended by the public defender's office?
Yes, they have a hefty caseload, but there are also a lot of private attorneys.
Thank you.
Yeah, it would depend on the case.
Supervisor Garamendi?
District Attorney, thank you very much. I was not here on this board last year when you did your budget request for the 4 positions. I sincerely believe that ban without enforcement means nothing, and enforcement without prosecution on criminal acts means little. So I see hand in glove with the Sheriff's Office and getting things under control. Can you tell me, bring me up to a little bit of history on why you weren't part of these fees and weren't able to tap into these fees, and then also sort of what the material impacts would have been of this for people you requested in the budget?
I would defer to County Council on the interpretation of Prop 26.
Okay, so we'll go to the 4 people.
The fees are to pay for the registration program and enforcement of the program. I think Supervisor Tofinelli described it perfectly last time when he said it was a licensing program. Mm-hmm. So if you think about that and the cost of what it takes to get through this licensing, crime that occurs isn't really part of the licensing scheme. Mm-hmm. except for you did something without a license, perhaps. So I think that's just a very lay explanation.
And the 4 positions that you requested, were they going to be cannabis related, or you're just down people in your office?
I identified that as a way to help our workload and how we were being impacted, plus be an active partner in trying to get a hold of the situation. One of the positions, kind of the linchpin of the unit, is the forensic accountant. And I felt that was very important because this is a cash industry, and that's the way you're going to get a hold of it, is to either support the industry or to ban the industry, to go after the money. If you envision the industry operating under strict guidelines, well, there are going to be cheaters in that. And the only way to get the cheaters out who are engaging in unfair business practices and undercutting the person who is spending a lot more money to do it right, you need somebody who can build cases based on the money. In addition, we're going to have the tax structure. So the ability to go after someone for tax fraud, workers' comp fraud, all of those things that legitimate businesses have to abide by. Well, and if it's a legitimate business, they would have to go abide by the same rules. But again, rules don't mean anything if you don't have the ability to hold people to task. So I identified the unit as in a couple of my memos in order to either go after the industry to make them not want to be here, or to support the industry. Either way, to my office, the cost was the same. And I think I'm not sure which supervisor asked the sheriff's office, how many years would it take, how long would it take? Yeah. And it would probably take our office about that same period of time, because the position doesn't actually exist in the county. It doesn't even have to be in my office. It could be in the sheriff's office. It could be, the tax collector's office if she wanted to get into it. But it's because of the type of industry and because of the newness and the technicality, and because it is a cash industry, I think that's what I came up with. There could be some better ideas out there, but that's what I identified as the costs to my office.
Thank you.
Any further comments of staff by the board? Okay, we'll open up to public comment. Once again, ladies and gentlemen, please be aware we have 3 minutes for each speaker. And before we start, could I see a show of hands who wish to speak? Okay. I want to remind everybody that we want to keep our fire lanes clear for the fire chief, so no more than 5 to 6 standing in the back at one time. Thank you. First speaker.
Actually, it says good morning, but good afternoon, board. We are here today to decide how the county will proceed with the cannabis issue. It has been recommended by county staff, pretty strongly, I would think, that we should continue the urgency ordinance for at least the maximum amount of 1 year. This would ensure the county faces no defunding of law enforcement, stripping of county regulation, and controlling legal cannabis cultivation, at least until May 2nd's vote. Then, if we face a ban, cannabis by the voters, you would have time to do so. We'd have that year in which to enact that ban, somehow fund that ban, somehow come up with the money that would be lost from Measure C if you do not renew this ordinance today. Before you adopt renew the UO, or not renew the UO, or ban, I believe there's also another need for an EIR. We've never faced a ban in this county and what that would do to the environment. We would know that every grow was illegal. Do you think those people were inspected? Give a crap about where they dump their stuff? Isn't that the complaint around here about most of the people? I also hope you're aware that in the past week, 2 bills were introduced in Congress. H.R. 715, the Compassionate Access Act, which would reclassify marijuana from its Schedule I class. Also, H.R. 975, to amend the Controlled Substance Act to provide for a new rule regarding the application of the act to marijuana and for other purposes. Both of those bills were introduced with something that's not been heard of in our Congress, bipartisan support. You believe that? actually Republicans and Democrats together on one issue, willing to regulate marijuana. Amazing thing. As you have or will have today, the physical impact report of $251 million to the local cannabis economy is more than any other industry by far in this county. That also includes some 3,400 jobs. If you continue not to vote for the UO or to vote for a ban before the election, you are personally taking responsibility on yourselves as elected officials to eliminate safe access by closing all dispensaries or safe access to marijuana in this county. The black market instead of never tested their products that I know of. Regulated cannabis sold through dispensaries is tested for molds, mildews, and other pathogens that may be on it. Sometimes you can't even sell your product to those dispensaries because it has that mildew, mold, or pesticide residue. Not us, we grow ours organically. I understand from some of you feel you were elected to rid this county of cannabis. Yet I hope you also remember the voters voted to tax legal cannabis businesses this year at $2 a square foot under canopy. Sorry, my time's up.
Thank you, sir.
It didn't beep.
You hear a beep?
No.
Is our beeper working, Madam Secretary? We can't see nor hear it now.
Hi, my name is Shelley. I'm a property owner. My son here, Robert, who's in a wheelchair. I'm working, the urgency ordinance directly affects us because I'm working with UCSF right now with his neurologist and neurosurgeon. All the other medications didn't work. CBD is working. We're going 3 or 4 days with no seizures. If you don't renew it and we can't do it, I don't know anybody that could supply his medicine. 1 pound lasts 26 days. That's how we do the oil. So a whole year would be, 12 pounds. So I don't know anybody that could donate that. I can't afford it. So that's how it directly impacts us. I'm fighting for my son's life. We've done everything the doctors told us to do. This is our new thing. We've been 1.5 years now. We're weaning his meds. Before this, he was having 3 to 4 seizures every single day. And again, now we're 3 or 4 days, even 5 days without any seizures at all. His quality of life is 1,000,000 times better. So for me, if we ban it, it changes our life completely. I'm not sure what we would do at that point, if we would try to move, how we go on. Because right now our life is good. Right now I'm excited about what Robert's future is. I'm excited that he gets to do things and laugh out loud, things he never did before. So I just ask that you listen to some of the medical side of it and have compassion for somebody like my son that doesn't have a voice of his own, can't grow medicine for himself, and that's all. Thank you.
Thank you.
Good afternoon, Mary Stebbins, District 1. I'm here to speak on behalf of a renewal of the urgency ordinance for the maximum time period allowed, which is 1 year.
Ma'am, could I interrupt you for a moment?
Sure.
Could you lower that microphone? There you go.
Boo, boo, boo.
Speak into
Better?
the microphone
Better?
for our folks out there. Thank you.
Boo. Do you want me to start over?
Sure.
No,
We'll give
because
you the time.
Okay. Okay, Mary Stebbins, District 1. I'm here to speak on behalf of a renewal of the urgency ordinance for the maximum period of the 1 year allowed. If the ban initiative does not pass, our county will need regulations to manage those registered to grow. It is important to ensure the board and an advisory board, the content of which is yet to be determined, have sufficient time to draft and finalize a permanent ordinance. I understand every resident can be impacted by having cannabis cultivation in the county. Those at most risk, in my opinion, in an unregulated environment are those living in close proximity to growers, of which I am one. I thus did a rough tally using the original PDF registration list published in 2016. I say rough because
All applicants do not have a city listed. Some have addresses outside the county. If a city is split between districts like Angels Camp, I simply took the count and divided it in half. And here is the rough numbers tally of growers by district. Tofinelli District 1, 226 applications. Garamendi District 2, 566. Olivieri, I'm killing your name, sorry. District 3, 44. Mr. Mills, District 3, 44. Mr. Mills, District 4, 106. And Mr. Clapp, District 5, I couldn't find any applicants. I did this tally because there must be a 4-to-1 vote in favor of the extension. And I don't mean any respect for any particular supervisor, but if the ones that have no applicants override the ones that have the majority of applicants, that doesn't seem fair to the county at large. I thus request that all supervisors consider what will happen to the residents in District 1 and 2, of which there are almost 800 applicants, if the ordinance is not extended for the full year and the ban initiative fails. Thank you.
Thank you.
Good afternoon, supervisors. Just wanted to take a couple of minutes to read into the record an email that I sent to all 5 of you, just so that everyone was aware of my feelings. I was unable to physically attend this week's study session, but I wanted to weigh in on what I heard while attending via internet connectivity. It seems as though the will of the people, as well as the majority of county heads, is meaningless to our current Board of Supervisors. Staff has been directed to begin writing a ban without identifying how the county would pay for it or how it might adversely impact those who are living here. I continue to believe taxation and regulation of the commercial cannabis industry in Calaveras County is the only way to ensure our safety and our longevity. Without these two things, the number of non-taxed, non-regulated grows will climb and anarchy will rule. I implore you to utilize and leverage the skills Supervisor Mills apparently has in process management to truly understand what is working with the urgency ordinance, as well as that which could be improved upon when addressing future methods of regulation. Perhaps eliminating small parcels in rural residential is prudent. Adding additional restrictions and fees, such as a RIM fee for those that register as commercial, would be appropriate. Gentlemen, I ask that you make your decisions with data, not emotions, and a desire to please the moral minority. I've invested a great deal of myself in Calaveras County, especially since the Butte fire. I've built my home here, and I have the intention of retiring here. Now I find myself handcuffed to a county due to impending litigation with PG&E that, in my opinion, is hell-bent on destroying itself from within. I implore you, do the hard lifting required to ensure there is a future for your constituents that is based on sound business decisions and does not sell out District 2 in the process. Calaveras County is better than that, and frankly, as a resident and taxpayer, I deserve better too. I ask you to really give this a chance. Take a look at the numbers, take a look at the cost of not moving forward with regulation that, quite frankly, does need to be readdressed. This wasn't perfect. But at the same time, there are a lot of good things that go along with it. Do the hard work, please. I ask you. Thank you.
Thank you, Mr. Moore.
Bob Bowerman, District 5, resident for 16 years, and just loving it. This isn't a question of whether you're pro or against cannabis. I think really shouldn't even come into it. This is a question of whether we want rules temporary or not. I'm not going to go back over everything that everyone keeps telling you, because you're probably waking up in the middle of the night going, wow, they're saying that again? Right? But this is a placeholder. That's all it is, okay? Whether we ban it or we regulate it, those aren't even in question here today. The question is, do you want rules or no rules? I don't think it's much of a question. I think the answer should be pretty obvious. I would really, really expect a 5-0 vote in favor of renewing this. That's the only thing that makes sense. But that's me, okay? But this is not whether you're pro-cannabis or against cannabis. This is, do you want rules or do you not want rules? The new rules coming up, whether it's a ban or what have you, we're working on that. You are, we are, a lot of people are. We will get there. But this is a placeholder. Keep this placeholder intact and keep our county safe. This is what we need you to do. A 5-0 vote, yes, on this. It's really a must. Thank you.
Thank you, Mr. Bowerman. Next speaker.
I think I know what you guys are going to do, and I'd probably do it if I were you, because you have to be responsible.
Ma'am, I want to ask you if you could speak a little bit louder into the microphone. I know it's difficult. There you go.
I know what you guys are probably going to do, and I probably would do the same thing, and I'm sorry, because one domino out makes all the dominoes fall. And millions are going to be spent between now and May, and they're going to be spent in favor of growing marijuana. And I've lived here for like 34 years, but the reason we moved here was because it was like Mariposa County, but it was commuting distance. And in Mariposa County, it's the real hazard county. But my dad was a gold miner, and when I was about 6 years old, I found out what fool's gold was. And I know the difference between real gold and fool's gold. And you don't do nothing with fool's gold. And that's what growing marijuana is. And unfortunately, the people of California and a lot of the rest of our states are not looking at that issue. And I feel that if you follow the money trail, after a couple of years, most people will not be able to bear under all the rules and regulations, and just follow the money trail, and you will find the good old boys and the deep pockets. Thank you.
Thank you, ma'am. Next speaker.
My name is Patrice Murphy, and I currently reside in District 1 of Calaveras County. I'm here to speak on a subject that has brought much concern, grief, and sorrow to not only me, but to thousands of the residents of Calaveras County. I'm referring to the decision made by last year's Board of Supervisors regarding commercial growing of cannabis in Calaveras County, and more recently of the current Board of Supervisors' failure to enact the ban against commercial cannabis on January 24th. Men, you are our elected officials. Your job is to represent your district and defend the Constitution of the United States. In our Constitution, we are guaranteed the right to life, liberty, and the pursuit of happiness. For the past year, for a tremendous amount of residents of Calaveras County, those rights have been compromised. My preference would have been that the Board of Supervisors would have enacted the ban against commercial cannabis, but since you do not, we've got a problem before us, don't we? I would like to remind you that Proposition 64 allows for local regulation and taxation of marijuana so different cities and counties may ban its growth and sale. The reasons that I and those who are in support of the ban have for the ban is for the constitutional rights and the protection, safety, and betterment of the lives of all the people of Calaveras County. The vast majority of those that are opposed to the ban on commercial growing of cannabis in Calaveras County.
Ma'am, can I get you to focus on the urgency ordinance extension issue?
Okay, yes. That's why I do not want you to, actually, I was going to ask you to not renew the urgency ordinance, but now I'm going to ask you to enact a ban now. I just recently heard today, and I haven't had a chance to follow it up, but I heard that there is federal funding for counties that enact a ban. I would like you to research that, check that out, whether you can do a temporary ban until the ballot measure or what, but that is something for you to consider. Men, you just heard, is the ordinance working well? No, unequivocally no. Why would you extend something that is unequivocally no, not working? Is discontinuing the ordinance a problem? Yes. We've created a monster. How about enacting a ban now? Is ordinance attracting violent crime? Yes. Why would you continue something that is unequivocally not working well, is attracting violent crime? I'm requesting that you consider a ban immediately. Thank you.
Thank you, ma'am.
Good afternoon, Vivian Seichu, District 1. From a root cause analysis and process audit and mapping point of view, and having listened to past and current discussions, comments from county department staff to growers and to the general public, it appears, as in our opinion clearly transpired from county staff's briefings earlier on, that the key issues surrounding the urgency ordinance are centered more around implementation and enforcement, rather than matters of ordinance content and whether the UO is succeeding or failing. Therefore, the key issues appear to be related to funding, process, and organizational arrangement across departments. There are not only issues to be addressed through regulation, but also through deployment and enforcement as well, particularly around law enforcement and related funding. A regulated market will provide the resources via Measure C and registration fees, whereas the rest of the efforts will be solely dependent upon good organization and the will to make it work. In a word, it's about people, their engagement, and personal collective leadership to collaborate and be effective in their professional actions. Once again, we need to operate with facts in hand. In that respect, before you begin the process of making any drastic changes here today, if the board should decide to not renew the urgency ordinance, we strongly urge each of you to carefully evaluate the efficacy of the changes associated with that decision in producing the desired results that you seek and the paramount consequences which will entail. If you are unsure that such changes will create the desired outcome you seek, then you should reevaluate your plan and decision. We hope that today's outcome will constitute a definitive step in the right direction towards setting qualitative permanent regulations. We fully support county staff and the Sheriff's Office and urge the Board of Supervisors to renew the urgency ordinance for a full year. And we would like to stress again, for a full year. This is a simple matter of insurance, and therefore, to dovetail back from where I first started, professional process management. It is merely a simple matter of responsible risk management. Thank you for your time and consideration.
Thank you.
Joan Wilson, District 1 voter. Gentlemen, last year the Board of Supervisors set up this urgency ordinance to maintain parity with the upcoming state laws. Ending it before its full term would certainly be short-sighted. If you do not renew the ordinance, some good farmers will leave. They'll be leaving this county to deal with growers that deal in the black market and cartels, having free run with no money to fight for the good people of this county. No law enforcement or lack thereof to deal with the problems that will arise out of that action. Wouldn't it be nice to support the businesses that are already here and have the money for you gentlemen to deal with salaries that are needed to draw talent and retain that talent and law enforcement that we have? County staff, law enforcement, and many others are depending on you to follow their recommendations and continue this urgency ordinance. You owe it to the people of this county to wait for the EIR. If you don't, now is the time to reveal a plan to pay for enforcement, since the state has made it clear that any county that does not regulate will forfeit money, our tax dollars, for eradication, drug rehabilitation, schools, etc. If that is what this board wants, they should wait for an EIR on a ban, because not renewing the UO is a ban. Permanently ending this ordinance is akin to aborting a child in the 3rd trimester. What legacy do you want to leave? A county with jobs and money in its coffers, or bankruptcy and lawlessness? Will you want to be the ones to tell the children that you don't care enough about them or their future to secure the money from cannabis and the state for education, drug rehabilitation, and law enforcement? Gentlemen, I just heard somebody stand here and tell you that there's federal money. I also heard that same person during lunch say that she couldn't find that verbiage that says that there's federal money.
I didn't have time.
Ladies and gentlemen, please.
I urge you to renew this urgency ordinance. See it through. Nothing's going to be fixed or changed or be right in a short amount of time. It's going to take time, and you've got that time. Thank you.
Thank you. Next speaker.
Good afternoon. It's Crystal Kesey, Eastside Environmental and District 1. I have a question. Was wondering if the public can get a copy of Captain Macedo's report that he presented today. It wasn't in the agenda packet information, and is that information going to be made available to the public? So that's my first question. And then kind of riffing on Supervisor Oliveira's question, when they did the breakdown of incidents in 2016 related to cannabis, how many registrants were involved? I'd like to see that broken down between registered growers and non-registered growers so that we have a percentage of crime that's committed by the law-abiding registrants.
Excuse me, ma'am. Are you here representing yourself as a private citizen or as an employee of Environmental Health?
No, I have an environmental consulting firm.
Okay,
Eastside
all right, thank you.
Environmental.
I was a little
I'm representing
confused.
myself as a District 1.
Okay, thank you.
Yeah, but I do consulting work for the registrants in the county too.
Oh, okay,
Yeah.
all right.
One, can we get the captain's report? Two, can we get a separation between the registrants and non-registrants for that list of incidents in 2016? Number three, the sheriff said that the urgency ordinance isn't working at all because of staffing issues. So number four is, and he can't have adequate staffing because of political instability. You can't hire someone, train someone, and then, maybe in 2 months we'll have a ban. We won't renew the urgency ordinance. So we're going to spend all this money training you, but in 3 months you're not going to have a job. I don't know very many people, especially in law enforcement, who would sign on to take that responsibility when they can have the rug pulled out from under them, especially if they have to relocate. And so if this issue is effectiveness because of staffing, then the answer to the issue is right around the corner. It's the Measure C tax that was passed in November. So I urge you to renew the urgency ordinance to the fullest extent possible, and I urge you to allow the growers to pay their taxes so that we can adequately staff every department that needs it, including the district attorney, so that the UO has a chance to succeed. Thank you.
Thank you.
David Juneau, District 5. I have done the research on federal money available for the enforcement of marijuana eradication. The numbers are in the billions. I'm going to request that this board ask for a more complete report than I would be able to put together pursuant to the notion that the request that several of you made at the last meeting for a board-initiated ban ordinance, I would like for the public to know that if either that ordinance is passed or the citizens' ordinance is passed, that the county is now not out there on its own. At the top of the structure in the federal government are three entities that I've identified: the DOJ, the DEA, and a separate program run out of the White House. As the money comes down, it kind of gets intermingled, and there are a number of different programs with different names on them, and they cooperate with one another, and they kind of transfer money and transfer resources. And there are a number of other entities that get involved in that, task forces and whatnot, even the California National Guard. The money is for various different things. It's a little hard for a person who's a grant writer could make out better how the money is distributed, what's required of it. But I can tell you about one requirement. You have to be an entity with a ban in place. They're not going to help you enforce a grow ordinance in your county or your city or your state. So the money is there. It takes more research than I've been able to do, but it's a tremendous amount of money. And it's for, much of it is for specifically disadvantaged counties, which we qualify for. A poor county with a big problem, a monster as it's been called. So it goes to us before it goes to other people, other entities. I would like for that report, even if it's a preliminary version of it, to be made available to the citizens in connection with your consideration of the ban ordinance that you have asked a draft of in the next few weeks. I think that discussion has to come together at the same time for the purposes that I've already mentioned. One of the previous speakers talked about money for our schools and our kids. If that was such a great idea, you'd have school officials for this thing, and they're not. They're all against it. And Dr. Bull from Colorado, who has a little bit more experience with it than we do, a superintendent of the largest district there, is quoted as saying, the only thing that marijuana regulation has brought to our schools so far is marijuana. Attracting talent to the county? Talent is not attracted to a third world toilet. And that's what we've become.
Mr. Turnout, please focus on the urgency ordinance. Thank you. Ladies and gentlemen, please.
Good afternoon, Jed Richardson with Mountain Ranch Realty. I have a handout there for you on real estate values. Last time I spoke to you, I presented data which showed that the urgency ordinance has been effective in stopping the land rush into the county for cannabis cultivation. There's also been significant discussion that real estate values have been negatively affected by allowing commercial cultivation of cannabis under the urgency ordinance. I'm here to refute that argument. The data I handed to you is from the California Association of Realtors website, and the data shows median home prices for California counties by month from January 2013 to December 2016. An analysis of the data at the bottom of the page shows that from 2015 to 2016, the average median home price in Calaveras County rose 11.3%, compared to Amador County, which rose 3.2%, and Tuolumne County, which rose 3.4%. Since a single year's data doesn't necessarily indicate a trend, I also calculated the average percent change in median home value for the past 4 years, indicating that Calaveras homes rose 11.6% versus 8.9% for Amador and 8.5% for Tuolumne. Also looking at the data from other areas, Calaveras beats all of the counties in the foothills and also beats the LA and San Francisco metro areas. It also beats California as a whole. The second page I had you is from the folks who oppose renewal of the urgency ordinance. That's stating that the median home prices only rose 0.5% in Calaveras County between 2015 and 2016, compared to the actual 11%. It also overstates the increase in value in Amador and Tuolumne by double the actual 3%. In the world of fact-checking, this statement by Mr. Tudo and Mr. McManus would be called pants on fire lies. As I have stated in the past, non-renewal of the urgency ordinance will open the floodgates to those with no regard for the law, a view echoed by the district attorney, cause a drop in the property values as legal growers leave the county, flooding the market, and cause economic hardship since growers will not be here to support local businesses. I urge you to renew the urgency ordinance for the full period so that we can get down to the very hard task of passage of a permanent ordinance. This is going to be hard work that we all need to participate in, and this ordinance needs to address the needs of law enforcement and all citizens of this county. Thank you.
Thank you.
Mr. Chair, I'd like a point of privilege. I'd like to have the speakers not be mentioning other people in the crowd's names. They should just be addressing the board, not people in the crowd.
Okay. Any comments on that from the board?
I concur. It's respect.
Ladies and gentlemen, please attempt to refrain from mentioning individuals located in the gallery and out in our foyer, and just as a common courtesy to those people and the board. Thank you.
Good afternoon. Megan Salvez, Rolling Hills Bookkeeping, San Andres, and I will only be addressing you board members. I want to start off with a couple of quotes. One was from the Union Democrat, June 8th, 2016, regarding Mr. Mills. Says that Mills will begin as supervisor as the start of next year. He intends to focus first on eliminating illegal marijuana grows. We need to make sure this county is safe, Mr. Mills said. Another quote is from Mr. Tofanelli's website when he was first running for election, saying that the previous board, instead of setting policy and allowing the experts to do their jobs, they have micromanaged in areas where they simply don't have the experience or expertise. Well, I was recently informed that the experts of this county here are the Planning Department, the Sheriff's Department, County Council, and the Environmental Management Agency. And these experts have spoken, and they've all agreed and recommended that the urgency ordinance be renewed to keep our county safe. The UO was designed to be a temporary fix until more permanent regulation could be put in place, but like any bandage, it needs to be left in place to do its job and reach its full potential. No, it's not perfect. Legislation seldom is. But it did the job necessary and will continue to do so if you let it. Just a few short weeks ago, this board voted unanimously to let the voters of this county decide whether or not to ban commercial cannabis in Calaveras County. Even a temporary ban voted into place by this board would not only cost the county millions in return registration fees and loss of Measure C tax funds, it will open this county up for potential lawsuits that errors and omissions insurance will not cover. Supervisors, the choice before you is a simple one. Wasting additional county resources on drafting yet another ban you already sent to the voters is a fool's errand. Renew the UO, work with your designated experts to draft a permanent ordinance, and let the voters decide whether or not to ban, as you already stated you would. In closing, I'd like to ask you all a question. Can you name a single industry available in Calaveras County capable of carrying our economy for the next 10 years other than cannabis? The facts point to no. And I'm sure you all are aware, money doesn't grow on trees, but a sustainable crop industry here that is coming out of the ground definitely can. Thank you.
Thank you. Next speaker.
Hello, everyone. My name is Courtney McKinney, and I'm in District 3. I only have one question that I would like to put before the board. Ideally, my question wouldn't be rhetorical, but one you ask yourselves daily as supervisors of the county. My question is, what are your proposals for economic growth and sustainability in Calaveras? I've spent some time looking for all kinds of long-term development plans for the county. I've looked for economic development plans, infrastructure plans, capital improvement plans, long-term tree mortality plans, anything really, and I found very little. My question is about the future of Calaveras County. Outside of cannabis, I have been unable to pinpoint any other industry with the potential to carry this county into its future decades like cannabis can. I have, however, been able to identify potential sources of weakness which the county will eventually have to respond to. The possibility for wildfires, the increased likelihood of deadly falling trees, the vulnerability of county roads and bridges. These are projects that will have to be paid for sooner rather than later, and it's not an issue of if, but when. There simply aren't as many products in our current economy that are as valuable and as relatively easy to manage as cannabis. and there aren't many climates so well suited for its growth like there is in Calaveras. To me, watching you toy with banning cannabis today is like imagining a decision to ban gold miners from Murphy's in the 1850s. Pioneering is the blood of this community, and change is part of maintaining prosperity. When we can't adapt, we disappear. And as far as I can tell, there aren't many options for this county that would provide as much economic possibility as cannabis. So if not cannabis, what? If you genuinely don't have time to find an answer to this question, it makes me nervous for the future of this county, and it makes me wonder if anyone in charge is really thinking about what Calaveras would look like in the next 10 or 20 years.
Okay, ma'am, let's focus on the urgency bill, please.
So I'll just leave you with a quote from the Visit Murphy's website regarding the mining industry upon which the town was built, and it should sound familiar, and it's relevant because we're considering right now not extending an ordinance, which in my opinion, if solidified, would be an economic benefit to the county. Building gradually, the wild days became a thing of the past, replaced with families, gardens, ranches, and dairies. Hundreds of permanent structures were built, including an opera house, hotel, churches, and schoolhouse. As gold waned, the townspeople remained to work sawmills and stores, farms and ranches, and added their own chapters to the history of the community. Thank you.
Thank you.
Good afternoon, Board. My name is Matthew, and I live in District 2. I'm not an attorney, but I've been a paralegal for a corporate law firm for 5 years. I also did their financials. In regards to the renewal of the urgency ordinance, from a legal and financial standpoint, it's a no-brainer, but I'm sure the experts and the affected department staff have already mentioned that. The issue I wanted to address today is the urgency ordinance is essentially a contract between the county and the applicants. In my years working at the firm, contract disputes and their resolution were a common matter. Underlying every contractual agreement is a fundamental trust between the two parties with regard to one another, as well as to the rule of law. This trust is at the foundation of our constitutional and representational form of government. Beyond the historical and cultural traditions that places contractual obligation at the heart of our democratic system of governing, there is also the pragmatic issue, and that's outside businesses that seek out stable regulatory environments in which there is a clear adherence to the rule of law. This means when businesses and corporations look to establish themselves in new areas, they look for security and consistency when it comes to local government, and they will pay attention to what happens here regarding the cannabis industry and the decisions of the Board of Supervisors. I think everyone needs to keep in mind the most important thing here is not the growers that want to farm on their land. It's not the good folks that want the inconsiderate neighbor gone. It's the future and the well-being of the county. And first and foremost, that means its economy, and that allows safety to follow, which is, I think, the most important. Thank you for your time.
Thank you. Any other speakers?
My turn, huh?
Yes, sir.
Okay, Bill McManus again. Hey, I just want to go back real quick. We're just going to point out some words and sentences I think you got to focus on, because words mean things, especially when they're in legal documents. When the previous board and this board either doesn't pay attention to those words, doesn't research them, but goes along with them, you own them, you're part of them. So I'm not accusing anyone of anything. Let's take a look at some of these words. Right from the urgency ordinance in section 17.95.120, in the findings, I'm not going to read it all, I think you know what it is. Under the Controlled Substances Act, marijuana is a Schedule I drug.
Mr. McManus,
Do
can
need
I
me to
just
stop
have you?
on this?
No, you'll have your time as soon as we find out what that is.
We ran out of tape. It's a little annoying.
The tape is, yeah.
Huh? Oh.
Never heard that before. The machine wants its turn, huh?
.120 in our findings for the urgency ordinance, where the drug is defined as having no currently accepted medical purpose or use treatment in the United States. Paragraph B, the Federal Controlled Substances Act makes it unlawful under federal law for any person to cultivate, manufacture, distribute, dispense, possess with intent to go blah, blah, blah. In other words, it's against federal law. This becomes a predicate that you're up against when you're doing something like an urgency ordinance. What this means is that you acknowledge that federal law says you can't do this, and then you go ahead and do it anyway. That is what they call de facto sanctuary. That is where a county puts itself above the federal government. We've already seen how other cities and counties have dealt with issues on a sanctuary basis. It hasn't turned out well for them. Right now, there are people out there cutting timber down. They're illegally grading. They are in violation of the general plan. They are not complying with the urgency ordinance. You have 34 people who have gotten a certificate out of 2,100 that are sitting out there. You want to tell the people that, hey, we're going to get tax money. Why do you think that they're going to be more compliant giving tax money to the county when they don't even apply for the application? It's not going to happen. It's a pipe dream. So do we want this to be a sanctuary county of Calaveras, or do we want it to be the rule of law? You know, when you go through, the one thing I would suggest, and I know my time is short, I would propose the following course of action for this board in regards to the urgency ordinance.
Thank you.
That the board proclaim
You were close.
that a state of emergency has and continues to exist in Calaveras County regarding public safety. Number 2, the board act upon an urgency ordinance to ban commercial marijuana. That the board draft a letter to President Trump, Attorney General designate Jeff Sessions, regional DEA, ATF, EPA officials, if we can get a ban. And the one thing we have to do from now on is support our sheriff's department. I keep hearing we can't enforce because we don't have it. I have sit through 3 years of budget sessions with the previous board and this board.
5 seconds.
Where's the money? Where's the money?
Okay.
Let's get it for them, and then let's get the job done.
Thank you. We gave 5 seconds to Mr. McManus because
Thank you.
I felt that our machine interrupted him.
How much that cost?
You don't want to know.
Aaron Elliott, District 4. Thank you, supervisors. I appreciate your service. I've heard some stuff about the UO being a monster, and I just gotta disagree. It's actually a foundation. It's groundbreaking, and it's pioneering, something that's very real in California. But if you do want to look at a monster, check out Siskiyou County up the top. They enacted a ban very, very similar. Thousands of houses, or not houses, 2-acre, 5-acre parcels were bought the first year. Thousands last year. All mostly a South Vietnamese group of people. They're really friendly. They're in it for the money, big time. Maybe 60 were abated last year out of these thousands and thousands. And the sheriff puts it in the newspaper, look, we did something. It's not stopping them. There's been emails from these people saying, please ban, because under 64 you do lose federal funding for abatement and enforcement. So they want you to ban. They don't want you to have ordinances. They don't want regulation on this industry. The industry's not going away. Please extend the ordinance and consider what's happening in the counties around you. We can learn a lot from all of them. Thank you.
Thank you.
Good afternoon. Dr. Prapana Smith, District 3 voter and licensed cannabis business owner. I want to counter the claims that the urgency ordinance is not working. We've had 2 visits to our site. The first one was County Code Compliance or Building, Courtney, and his assistant and 2 CHP officers. That visit was fantastic. It was cordial. It was professional. It was the kind of interactions that we need to see between our government and our business owners. The second visit was from the Agricultural Department. Justice and Catherine came in from the Ag Department to measure our scale. And Justice had this really beautiful, nifty little kit to weigh the scales of all the different sizes. He was trained in how to do the job to verify the accuracy of the scale. Ours was off by 0.6 of a gram, so I had to calibrate it right there in front of him. He couldn't calibrate it. The law requires I to do it. We got it right, got it perfect, and it was a fantastic visit. It was really professional. It was exactly what we need in this county. Justice is one of the people who will lose his job if you do not renew the urgency ordinance. Let's talk about the crime. Mr. Garamendi pointed out that he has an objection to violence, a moral objection. Well, I concur. And so if we don't get a renewal today, we're going to have some serious problems out there, and you guys will be owning it. If you do not renew the urgency ordinance, I'd like to request to know the date of the auction. Because you're going to have to sell that nifty kit. I want it. I want to buy that thing. Put it up for option. I'll buy it after you get rid of the urgency ordinance. There's a few cop cars. There's a few trucks. There's computers. There's all kinds of stuff that you bought with our money. Put it up for auction so we can get that money back to the people who that money belongs to. Thank you.
Thank you.
From District 5. I just wanted to share that the election's over. During the campaign, talking with your constituents, you take a stand on different things based on the information that you had at the time. And as a supervisor representing all the people, it's my hope that you'll continue to process the data and make better informed decisions as you go forward. To stay with what you said before with new information doesn't set right for me. Stating that a majority of your constituents want a ban or regulations is, in my humble opinion, a mistake. There's no way you were able to speak with all the voters in your district. Quite the contrary, you probably only heard from a relatively few based on the number of people that you would be representing throughout the whole county. To take that position is the equivalent of 5 people making the decision for everyone and disregarding the ballot process. If you really want to represent all the people and ensure their voices are heard, which we've talked about today, you'll extend the urgency ordinance and require an EIR so you and the voters can make decisions based on a deeper well of information. So, thank you very much.
Thank you.
Hi, my name is Jackie McGowan, and I just wanted to correct some misinformation that was just presented here regarding the federal law. This is information coming from a Senate Joint Committee meeting on the path forward after Prop 64, which took place at our Capitol just 1 week ago. In the background paper that was submitted to these committees, it states that, on August 29, 2013, the Department of Justice issued a memorandum, commonly known as the Cole Memo, which updated its guidance to all United States attorneys in light of state ballot initiatives to legalize the possession of small amounts of cannabis and provide for the regulation of cannabis production, processing, and sale. While the memorandum notes that the illegal distribution and sale of cannabis is a serious crime that provides a significant source of revenue to large-scale criminal enterprises, gangs, and cartels, it also states that the Department of Justice is committed to using its limited investigative and prosecutorial resources to address the most significant threats, which include the prevention of, and several things, but it says that the Department of Justice, in jurisdictions that have enacted laws legalizing cannabis in some form and that have implemented strong and effective regulatory and enforcement systems to control the cultivation, distribution, and possession of cannabis, conduct in compliance with with circumstances consistent with the traditional allocation of federal, state efforts in this area. Enforcement of state law by state and local law enforcement and regulatory bodies should remain the primary means of addressing marijuana-related activity. The memorandum suggests that the existence of a strong and effective state regulatory system and a cannabis operations compliance with such a system may allay that the threat that an operation's size poses to federal enforcement interests and encourages federal prosecutors to review cannabis cases on a case-by-case basis and consider whether or not the operation is in compliance. Also, in December 2014, Congress passed as part of an omnibus budget bill language that prohibits the United States Department of Justice from spending funds to intercede in state efforts to implement medical cannabis. This amendment, known as the Rohrabacher-Farr Amendment, is right now in effect until April 28th of this year.
Thank you. Next speaker. Ms. Montgomery, I want to apologize. This morning you were here. Thank you for coming back.
Apologize for my procedural blip. Alice Montgomery, District 3, State of California Registered Environmental Assessor, but I'm here just to talk to you about the urgency ordinance mostly. I concur with Bob Bowerman, actually. Where are you? That we should extend it just to give us time to get things right. Second thing, I would like to suggest that we hire an outside expert consultant. It's nothing saying about our county staff and how wonderful they are. It's just if I was them, I wouldn't want to touch this with a 10-foot pole. Get somebody who does this. You don't hire your dentist to work on your knees. So you get an outside consultant. That's all they do is work on something like this because there is so much involved. And I only know the environmental portion, and that is super complicated. So everything else has got to be more. That's my suggestion. Who do you get to pay for it? The growers. If they want it, they pay for it. Find funds to appropriately create an ordinance, administer it, enforce it, mitigate, and remediate. Also, we really, really need a forensic accounting back to May 10th, 2016. I don't know of anybody that knows how much this whole machine costs. So if we're going to do it correctly, we really do need to know, and I really appreciate that Barbara Sagast for that. I originally suggested $1.75 to $2 million like way over a year ago. I was woefully inadequate. If Captain Macedo says it was $627,000 for labor for half a year, that doesn't account like his one shots that he bought. We are way low. We have no idea. This other thing is we need to get in follow-up. We have to budget for biannual, which means every 2 years, an independent audit of this program. If you want to make a best of program, then you get an outside audit and you have it audited every 2 years. And then we know, and then we have best practices. These are my suggestions. I really thank you.
Thank you. Any other speakers?
Hello, Board. Trevor Whitkey, CCA, District 2. So we've had basically every department now advocate the renewal of the urgency ordinance. Even the district attorney got up here and called for a full renewal of the urgency ordinance. It's essential for public safety. That is the reason why they're calling, every department across the county is calling for the renewal. There is no alternative enforcement plan to regulations. I've heard the suggestions that fees and fines will be an option. Fees and fines simply will not be an option for enforcing the issues associated with cannabis cultivation in this county. Only strict regulations funded through Measure C will provide the funding that we need to actually get strict regulations on the book. As I said before, there's a 6% recovery cost that we found out from the study session last time. $500,000 in fees and fines have gone out. $30,000 has been recovered. That's a 6% recovery fee. And it just so happens that is exactly the same as what Butte County was able to bring in through fees and fines when they enacted their strict ban on commercial, allowing for a small, limited amount of personal grows. The strategy doesn't work. David Tuno came up and spoke to the issue of federal enforcement. Don't go this way?
No, no names.
Okay, excuse me. I apologize for that.
That's okay, that's all right.
Yes, so people have suggested the possibility of seeking out federal enforcement monies. The issue that we have with this is the Rohrabacher-Farr amendment that currently makes it impossible for the federal government to go after compliant states, Rohrabacher-Farr makes it so the federal government can allocate funding to enforcement. There's the Cole Amendment, or the memo, which makes it so the Department of Justice is not allocating funds to enforcement in legal states. This is a big issue. We are not going to have access to funding anytime soon through federal enforcement. Captain Macedo got up last time during the study session and spoke to the difficulty of recuperating funds through the federal government. Specifically, he talked about reimbursement process for DEA grants. That means we have to spend the money and then reimburse it on the back end. And if we don't have the money to spend now, then we can't be getting reimbursements on the back end. Additionally, it creates budgeting problems, as he had spoken to. There needs to be changes in federal law and policies to get access to those funds. It doesn't look like that's going to happen regarding given Jeff Sessions' recent comments that it is not a priority for the federal government to intervene in this issue. So,
Thank you, sir.
yeah, thank you.
Next speaker. Any more speakers for public comment?
Kaz Tomaszewski, Calaveras Cannabis Alliance. As we heard today under a previous agenda item, staff is currently aggressively pursuing solving the issues with enforcing the UO. Whether it be improving response time, bringing people to justice quicker, or implementing the largest illegal grow eradication campaign perhaps in the history of the country, staff is on it. There are those that think this process is taking too long, and this is too little, too late. However, it's important to note that any program that the county could implement, whether a regulation or ban, would take 1 to 3 years to be effective. Any program that addresses a total of 2,000 grow sites, utilizing multiple departments and broad enforcement action, is going to take Calaveras multiple seasons to bring things under control. The only difference is that under a ban, there is no viable funding source yet identified for effective enforcement. Not a single county in California that has a high draw for growers such as ours, in our case due to climate, has found a viable funding source for effective enforcement. For example, the fine-driven system, look to Butte and note the 6% collections. The program is hemorrhaging money. For example of what happens when you rely on state and federal assistance, look to pre-regulation Humboldt, worse environmental damage in the state. As for asset forfeiture, Prop 64 took cultivation and possession felonies and made them misdemeanors, meaning that criminal asset forfeiture in most situations is no longer an option. And as for civil asset forfeiture, when consulting attorneys about the county's chances of pulling this off as a funding source, the response is often laughter. As for a special tax for eradication, no one thinks it has a snowball's chance in hell of passing in Calaveras, considering our resistance to taxes. Not a single official has provided a plan for how to solve this equation. Now, I understand that there are people who have been unable to stomach the enforcement delay of the UO. There is a belief that the urgency ordinance is a grand experiment with an uncertain outcome, and that taking the risk of such an experiment would be irresponsible. An intuitive leap from this standpoint is to shut down the UO and institute a ban. But the solution is not that simple. What these constituents are asking you to do is to go for an option that has been proven not to work over an option that has not yet reached a point where it can prove that it could. If you handed these critical constituents what they wanted, it would come at broad approval of these constituents. But without identifying alternative funding sources, it would also come with moral damage to the economy and public safety. Failure to extend the UO long enough to allow staff to roll out their solutions and reap the benefits of tax revenues will be cutting off the imminent reveal of what might be our only viable option in this county, no matter what we might like. I understand that as representatives, you need to give your people what they want. Instead of an unworkable ban, consider for a moment giving the sheriff department a chance to pull off the biggest eradication campaign in history with our tax dollars. That might do the trick. Thank you.
Thank you. Ladies and gentlemen, are there any more candidates for public speaking?
Good afternoon, gentlemen. My name is Larry Bridges, San Andreas. I would just like to address one issue for each and every one of you. First off, welcome to the new members, and thank you for your considerations. Particularly, I believe Supervisor Oliveira, there was an issue before this board about a year and a half ago, and you were very adamant that you felt that that decision should be made by the voters of this county. And I would ask that you show the same consideration on this issue. Let us not forget the patients and the underprivileged and the poor people out there that don't have the money or the transportation to be able to get an alternative to the opiates that are on the marketplace today. For those of you that saw the newscast this morning, I believe the number was in excess of 20,000 people died in this state last year as a result of accidental opiate prescription medications. So please take that into consideration. Thank you for your time.
Thank you. Ladies and gentlemen, any further speakers on the public comment? Need a break? While we have a short lull, could I see an indication by a raise of hands how many speakers that will be speaking in the public comment?
And how many are in the lobby?
Can we, in the lobby, is there any of the public speakers that desire to speak? Okay. I'm sorry. Hello, how are you?
Hi, Dina Morris, Calaveras County citizen. The UO has to go. I just listened to our law enforcement confirm what I already know, that this has created a monster in our county. The ordinance is attracting violent crime. Again, I already know that. It's the nature of the industry. Nobody's saying that. They're talking about the farmers. This is the nature of the industry. It's a crime-ridden industry that many of us have been handcuffed to with no payout forthcoming. What other agricultural products being grown require so much time and money from our law enforcement, our district attorney, code compliance, so on and so forth? None. Why would you want to continue to force this industry upon us, upon our children, upon our families, upon retirees, our communities? Can you think of another industry that carries as much crime as this one does? We're talking about growing a product. I can't think of another agricultural product that's being grown where the growing of it attracts so much crime. Pioneering this county with this type of a product being grown here is literally going to leave blood on some citizens. We've already seen it. It's not going to disappear with UO. Criminals coming in here to steal it, they don't care whether we have an urgency ordinance or not. They could care less. And as far as getting money from Prop 64 to help, we're at the bottom of the barrel. Counties are at the bottom of the barrel on that list. So we'll see little to no funding from that. So again, I say that the urgency ordinance has to go. Don't kick that can so far down the road that you're going to force us to go through another season of crime. Thank you.
Thank you. I understand there's one more speaker, 2 more speakers, 3 more speakers, 4 more. At this time, we're going to take a 10-minute break for our clerk. Thank you.
Thank you. My name is Catherine Lambie, and I've been living in the West Point area for over 25 years. I'm also the director of the Blue Mountain Coalition for Youth and Families. We've been operating a youth and community center in West Point for more than 20 years. I just would like to give a slightly different picture of the perception of growers in my community. West Point is the little community at the end of the road, often forgotten by everyone. We have really high unemployment. Our schools are always threatened with closure. We have to constantly be vigilant about that. Recently, we've had an influx of young, pleasant, smart people and families. They put their kids in our schools. They are helpful. They donate generously. They are volunteers in our large community garden and at the school. They want to be involved. They want to pay taxes. They want to be participants in our community. They want to grow roots. They do not want violence or crime. They have been a real asset to our community. And we are an aging community. It is a welcome influx of young, productive people. Thank you.
Thank you.
I urge you to continue the ordinance. Thank you.
Thank you.
Sue Holber. I live in the burn scar in my little trailer until I rebuild or take it somewhere else. What I have to say is really simple. Right now, we don't have a ban. We don't have a permanent ordinance. We don't know when there's going to be another. We don't know when there's going to be another emergency, like the fire, that we can't predict. The only safety net we have right now is the urgency ordinance. Please don't take it away.
Okay, thank you.
My name is Kurt von Puttkammer. Was brought to West Point about 3 years ago. I'm a registered architect and land planner and a licensed general contractor. I came up here to grow, or was offered to grow sustainable, natural, organic setup grows. Very little impact to the environment. I want to share a story, not a story, a conversation I had with the business owner, the biggest and oldest business owner in West Point, no names. We've become friends for the last 3 years. He took me aside yesterday or 2 days ago and he asked, what's going on? Why would they possibly want to retract the ordinance? And I said, because they think it doesn't work. And he looked at me straight in the eyes and he said, I know the people who come through my door, it is working. Thank you.
Thank you.
My name is Reed Larson, District 2. I want to encourage you today to readopt the urgency ordinance. Let's look at Butte County, where $2.93 million has been assessed in fines to illegal cultivators there, and only 6% have been paid. They also have hundreds, if not thousands, of cultivation sites in the Feather River watershed that are going without Water Quality Control Board oversight and regulation. This is because Water Quality Control Board is preempted by local regulation. Now juxtapose these policy failures of Butte County against Desert Hot Springs, where we're seeing city leaders stand with community members at a ribbon cutting ceremony when the new cultivation site in town is opening up, while they simultaneously receive a $135,000 tax check representing their first installment of tax payments. That's what regulation could look like. Please readopt the urgency ordinance. Thank you so much.
Thank you. Any more speakers for public speaking or public comment period? I believe Sheriff DiBasilio had a comment. We're going to allow him to come up twice. He has a gun.
I appreciate that. Thank you, Supervisor.
Smart man.
Now I feel of some importance. I just wanted to clarify a couple of comments that were made. I don't know if it was Captain Macedo or myself that said the urgency ordinance was causing problems. I want to be very clear. The urgency ordinance did not cause the problems that we're having. The problems that we're having are because of the Butte fire and an ordinance or a ban not being put in place in a timely manner. And I know the past board was trying to see what the state was going to do. AB 21 rolled around, and in March 1st, they said, okay, we're not going to mandate that the boards or people put something in place in their county, or you're going to fall under the MRSA laws. So I want to be clear that That was not our intent, if that's the way it came across. I still say that the urgency ordinance that the past board put in place did help. It has moved us in a forward progression at this point. It is slow, I will admit that. It is problematic, I said that, and I still stand by that. But it's better than not having anything. I just want to be very clear about that. And to me, again, I want to reiterate it, that the urgency ordinance is insurance. If you extend the urgency ordinance for 10 years, it doesn't matter if you guys do something else, and it doesn't matter if Measure B passes. That's the bottom line. You need to have some insurance for our county, and this urgency ordinance is that at this time. Thank you.
Thank you, Sheriff. Ladies and gentlemen, before we bring it to the board, is there anybody else during public comment? Okay, thank you. I'll bring it back to the board. Comments, questions? Supervisor Clapp.
Yeah, well, I got mine. I mean, there was insinuated that like we ran on something to get elected, but didn't really mean it. So this is what I put out. I paid to have it published in 2 local newspapers. And it's very simple. It's about 50 words. And it says, "Hi, my name is Clyde Clapp, and I've been your neighbor for the past 38 years. And with your help, I'd like to be your supervisor for the next 2 years. With us working together, we can keep heavy industry and commercial cannabis grows out of our neighborhoods where we live, play, and raise our families together." And I was serious about that when I ran on it. And the people that supported me on this reason. And there was another gentleman running against me that was anti-cannabis. And if I ran on a lie, he should be here and not me. And that's how I feel about it. I didn't run on that statement just to get voted. I ran on it because that's what I truly believed, and I don't like what happens to my neighborhood. My neighborhood is horrible in the last 12 months.
Supervisor Mills?
Yeah, I think this board sitting here today isn't the one that created what we're talking about today. You know, this is not something that we made, we inherited it, and we're going to have to deal with it in one way or the other. And I think every city and county in California is dealing with it in their own way. Am I familiar with Prop 26? Here it is. Am I familiar with the call memo? Yes. Am I familiar with the Rohrabaugh Fire? Yes. I got to go back to what James Madison said as the founder of everybody considers him the father of our Constitution and the Bill of Rights, where he said if men were angels, there would be no need for government. And so government becomes the intercessor when people decide to do things which are contrary to the normalcy of the society in general. I've watched the machinations as this UO was developed over the years. I think the only other person who spent more time in these halls, other than maybe Kaz, was this guy right here. Because I was sitting out there during that whole time. So I've watched it all happen. The only control that we have right now is in the near term. And everybody says, well, Measure C is the answer. Measure C is going to give us the money. But if you think about budgets, when is the first amount of money going to roll in? It won't be until the 17-18 budget. That's June, July, if you're lucky. And that's only going to be about half of it, if that. My wife's an accountant. And accountants oftentimes ask businesses one question: what do you want the data to show? Because they'll make the data work for whatever you want it to say. So when people throw me paperwork that's got all kinds of numbers on it, of course, it's going to always be tilted to the favor of what they're trying to promote. I want to remind everybody that the governor's emergency or urgency ordinance that he has in place regarding water and the drought is still in place. And he is pushing forward with 20% domestic water reduction by 2020, no matter what the counties think. That means that all of those who decide to grow indoors are going to have to be faced with that possibility of verifying that they're reducing their water sources. So I think the thing to think about here is that what do we have, what can guarantee us a future until we can get to that permanent spot? And that's really what it's got to come down to. So Just my thoughts right now.
Thank you, Supervisor Mills. Supervisor Tofinelli?
You know, I could address some of the comments that were made. The one about what our platform was when we ran. And I was very adamant. I met with both sides. I took a tour of farms when I was running. I was reached out to. What I saw was very well organized, very well done. There's no question about the ones that I went to. But my concerns are, and I said at the time, that I think that the county should wait until 2018 to find out what MRSA is going to be. I ran on that platform. I ran on the platform of getting it out of residential areas. It doesn't belong there. It's a commercial operation. Most of all of the complaints that I get are from residential areas. In my personal belief aside, that is what I ran on, and that's what I sit here today on. I have not changed from that. We as a board here, and also our duties here, as most duties of government, is to provide safety to the public on all sides of it. No matter where you are out there sitting here today, on what side of this issue or any other issue, who knows what's going to be in the future, the next big issue. It seems like I've been here before and there was other issues when I first got on. Much like this time, there was a big issue then when I first came on the board last time, and that was the golf course down there. And there was people on both sides all over the county on the golf course. It was a huge issue. So there's always going to be issues coming forward here anywhere, not only this county, but in cities, the state, the nation, and so forth. But the primary function of what we need to look at here as a board is what's going to provide the public safety. I know that the sheriff spoke, and some of the things that he said stood out of my mind, and I even spoke about when I was campaigning, and speak about now, is there are still 9 open funded positions in the sheriff's office. And there's been a long-standing openings in that, being able to retain the people there to fill those positions so he can do what he needs to do to provide the safety to the public. The other thing that's being talked about here today, and I think everybody was very passionate on both sides of what they had to say, but at no time was this urgency ordinance put in place to be a permanent ordinance. It's always been a temporary ordinance. So saying that it's going to work 3 or 4 years down the road, it was never put in place to work 3 or 4 years down the road. It was only put in place to be a temporary stopgap until a permanent ordinance could be put in place. So I think you are losing sight of the fact of when you speak about this urgency ordinance. Even if we extend it for a year, it's a temporary ordinance. It's supposed to be put in place by law until you get, again, a permanent ordinance put in place. And I think it's our task to do that. And we may not be taking the path that's very visual or very insightful to people on how we're getting to that point. But again, we were put into this. 4 new board members are here today. We were put in here in trust that we could figure out what needs to be done and make everybody feel safe, and we're not going to make everybody feel happy. I'll tell you right now, there's going to be people going, no matter on this item, no matter what we do, we're not going to be able to split the baby and make everybody happy. It's just not going to happen, but hopefully we can get to a place where everybody feels safe about it and understands what we're trying to do and understands why it was done, what it was done. Things were done in the way they were. I do have a couple questions of County Council. And one of the questions that I had is, some of it was answered. I think the DA started down the path. on what the state laws are governing where we are in California. I know, with Prop 64 passage in November and a couple other things that were going on, it may be a little bit different than when this urgency ordinance was put into place and was claimed. But if we were to deny or just let this go, what would happen? Where are we with the laws in the state of California?
If the urgency ordinance is not extended, we would have no local regulations. So any state law that is in effect would apply. So all of the state laws that are currently in effect are the Compassionate Use Act, the Medical Marijuana Program Act, MRSA, and Prop 64. Those are all 4 separate areas of law that are on the books at the state level. As DA Uke indicated, under the Compassionate Use Act and the Medical Marijuana Program Act, the collective model of growing would still be allowed. So if the regulatory program, the urgency ordinance, is not extended, I would suspect that many growers would go to that model because those laws are still on the books at the state level.
Thank you. One other thing I wanted to bring up. I appreciate all of the emails and phone calls that I got. Obviously, it's a very, very, again, emotional topic. There was a lot of emails sent. I appreciate everybody for telling me what district you were in, and I didn't have an opportunity because of the volumes of them to respond to all of them. I tried to primarily, during the cost-effective of my time, or better use of my time, was trying to respond to the ones that said they were in District 1. So a lot of my responses were to the people in my constituents in District 1 in the emails. But I will tell you this, I did receive some emails that I consider threatening. And I'll tell you, I'm not going to be intimidated by threats by anybody on any emails or to my face or on a phone call on how to vote on something. You're going to turn me away. I'm an iron worker, so I'll tell you what, I've been doing it for 45 years. You're not going to get me with a threat, no matter what. You're not going to tell me I'm going to have blood on my hands. I did not initiate this to have any blood on my hands going forward. I'm not going to be intimidated that way at all. So any future ones going in, I'm telling you, I'll read your emails, I'll try to respond to you, but please use dignity and try and understand that you need to explain your position clearly and not try and put it in a threat to any of us here. Because I'm sure some of us, if not all of us, got some of those emails. It's just not, it doesn't reflect well on you or your side or what you're trying to accomplish when somebody does that. It works against you. So I think I'm done. Chair.
Thank you. Supervisor Garamendi.
Thank you, Mr. Chair. I tend to agree with Gary on a lot of, trying to get back to people's emails and the tone that we need to set in our county. I want to also recognize that there is a lot of passion around this issue, and I truly believe that people on both sides of this issue are passionate because they believe that what they're doing is in the best interest of the county. And I hope that you will all respect that what we do, we believe we're doing what's in the best interest of the county as well. And we need to foster that atmosphere of respect and understanding as much as possible. We could always agree to disagree, but we all live in this county together. I personally feel very privileged to be sitting up here at this time, and I feel very humbled by the responsibility and the trust that people put in this board to make major decisions that impact all of our lives. I thought it was profound to hear, District Attorney Uke, Sheriff DiBasilio, planning directors, environmental health, all coming together with great unanimity to ask us to do an extension for 1 year. I think it's a responsible act. And they're asking us up here to act responsibly. I think a vote to extend this urgency ordinance for 12 months the maximum allowed. Doesn't mean you're for cannabis. It doesn't mean you're against cannabis. It is simply the insurance policy that we must have to be responsible for this county. I spoke earlier about feeling privileged and humbled and with the responsibility. I think it would be irresponsible not to extend it as far as we can go. Just to cover, we don't know what the future holds. We're going into very uncharted waters. We're going to learn a lot. There's going to be waves. There's going to be obstacles. We need to have flexibility, and this does that. So my question would be, should we not decide to schedule it for, extend it for 12 months? Why? Why would we not? I mean, if I bought an insurance policy for a year, I'd hardly write my broker and say, I'm canceling it after 6 months. Thanks for taking my premium. So I don't see what the risk is for going for the full term. And I don't see what would be gained by not going for the full term. So those will be the questions as we move towards a vote that I have. But this is important stuff. Thank you.
Thank you, Supervisor Garamendi. Well, ladies and gentlemen, it's my turn, and I promise to keep this very short. I was the dissenting vote on the original ordinance developed by the last Board of Supervisors. I did that because I saw the defects in the urgency ordinance. But we are in a position right now to put this county, maybe this county is already at risk, and we have an opportunity to minimize that danger, even if temporarily. If we don't have some type of ordinance in place, we cannot survive what's in the future. And I'm going to say something probably that you're going to say, wow, what's he talking about? Let's take cannabis out of the picture. Let's look at our public safety right now. We are 9 positions down in patrol. There's 24 positions allotted to our sheriff's department. I know, I worked it. And if you think this is just going to blow over, it's not. We have to have that insurance policy to give us time to establish either an effective program to deal with this cannabis problem and the associated problems it brings with us. Now that's fine and dandy for me to get up here and jump on the soapbox, but let's take it a step further. On May 2nd, there's going to be a vote. I have always supported let the people decide. That'll be that opportunity. And I've also heard, well, if this occurs, it's not my problem. Ladies and gentlemen, it's my problem. It's Supervisor Tofinelli's problem, it's Supervisor Garamendi's problem, Supervisor Clapp's problem, and Supervisor Mills' problem. And I will not sacrifice the public safety of this county if there's anything I can do to prevent that. Told you it was going to be short, folks. That's it. Anything from staff? Any comments? I would entertain a motion for item 28 on the agenda. And please understand, and in fact, Madam Clerk, would you read the title for me?
Resolution extending the applicability of Chapter 17.95 of the Calaveras County Code, an urgency ordinance regulating medical cannabis cultivation and commerce for a period not to exceed 1 year.
Okay. I would entertain a motion to item 29.
Chair?
Mr. Supervisor Tofinelli.
I do have a question with County Council.
Okay.
Anything that we do here other than letting it die, any motion that's made, whether to extend it a year or 2 months or what have you, we will need 4 votes.
Correct. The urgency ordinance, any extension of an urgency ordinance requires 4/5 vote.
Okay, I just wanted to clarify that.
Yes.
Okay.
Mr. Chair, I'd like to make a motion to extend the application of Chapter 17.95 of the Calaveras County Code and emergency ordinance regulating medical cannabis cultivation and commerce for a period not to exceed 1 year.
I have a motion by Supervisor Garamendi to continue the urgency ordinance for a period not to exceed 1 year under Section 17.95. Do I have a second? I will second that motion. We don't need public comment, do we? We already had it, I'm just making sure. We have a motion and a second on item 29. All in favor indicate by saying aye. Aye. All opposed by saying no.
No.
Sorry,
Motion.
could you please clarify who was no?
You want to poll the board?
We can actually roll call vote.
Okay.
A roll call vote, once again. Supervisor Tofinelli?
No.
Supervisor Garamendi?
Yes.
Supervisor Clapp?
No.
Supervisor Mills?
No.
Supervisor Olivera? Yes. Okay, motion fails, 3-2.
I would like to make another motion, Chair, before.
We're still in session, ladies and gentlemen. Thank you.
I would like to move that we extend the urgency ordinance until the time that an ordinance comes before us, a permanent ordinance comes before us, and is adopted and put in place.
Council, comment?
I just want to clarify, any permanent ordinances that this board were to consider, once a permanent ordinance is adopted and becomes effective, it would automatically
Correct.
override the urgency ordinance. So the urgency ordinance would automatically terminate.
And I fully understand that.
Okay.
I fully understand it. I'm trying to get a place where we can get 4 votes here. Obviously, we didn't have 4 votes extending it for a year, but we may have interest with 4 supervisors that would like to extend it for a period of time. We have an ordinance that we coming for us that we asked to be crafted 2 weeks ago. And we're looking at possibly going forward with that to the Planning Commission in March and having it come back to us at the end of March and for a vote or review. And I'm not in favor of leaving us hanging out there during that period of time. I think the insurance policy needs to be there going forward with this urgency order, albeit I disagree with it. I don't think it's working either. I don't think it's right. I don't think it was crafted correctly with the residential areas being involved in it and a lot of the other things, but it does give us some regulations in place until we get to a period either in May after May 2nd or to the point where we get an ordinance crafted by us.
Chair, I have a question. I'd like to ask council, is the ordinance required to be date specific?
I'm not sure.
Is the extension of the ordinance required to be date specific?
It cannot exceed 12 months, so.
But it does not have to have a set date.
No, other than it not to exceed 12 months. So
Okay.
you can choose any time, similar to the prior board extending it for, not for the full amount that they could have. They decided to set today's date. This board could do that, but the board needs to know that under the government code, the county can only extend the urgency ordinance twice. So this is the second extension. So whatever this is extended for, it can't be extended further anymore.
Supervisor Tofinelli, could you restate your motion?
I would like to place a motion that we extend the urgency ordinance to a period of time that it goes at least till May 2nd, or after May 2nd, till we craft an ordinance that comes back to us. So we've already put the steps in motion 2 weeks ago to have that ordinance crafted. It won't be to the planning commission until mid-March. Then it will come back to us. It will either we move forward at that point with it, or we extend the time, or whatever we do until we get to the point where either May 2nd comes, or if it doesn't pass on May 2nd, the People's Initiative, we go forward crafting our ordinance. I think we need to move in that direction anyway. The urgency ordinance, like I said, was not ever meant to be a permanent ordinance. It was always meant to be a temporary ordinance in order for the county to get in place a permanent ordinance to address this issue. I don't think it's going to take a year to get to that point. And even if we went forward with a year, again, when a permanent ordinance comes in, it dies anyway, it goes away. But we don't know, again, what's going to happen in the future. We don't know what's going to be. Even an ordinance, if we get in place before May, what happens on May 2nd, if the People's Initiative passes, it doesn't matter what ordinance we have. That becomes law. But I think to leave ourselves out there unprepared, or at least some type of regulations, what again, the urgency ordinance, I've never been in favor of. I don't think it addressed so many issues, especially in residential, but at least it affords the county some regulations in the time frame that we need some type of regulation. And that's my opinion.
Well, I see it though
That's
as,
my motion.
Supervisor,
so you put in a motion, that's your motion on it?
I motion that we put in place, going forward with the urgency ordinance until time that a permanent ordinance is in place.
With no time deadline.
Well, if it
All right,
takes 1 year, if you know,
gentlemen,
if it goes,
let's clarify Supervisor Tofinelli's proposed motion.
Trying to get out of the dates, but I'm trying.
I think I understand what your position is. Correct me if I'm wrong. I understand that you are moving to put in place a permanent ordinance at a date after May 2nd, when the initiative goes to public ballot, and continue the urgency ordinance until such a time as those two events occur. Is that correct?
Either one or the other occurs.
That's right.
Either
one or the other. Is that correctly stating your motion?
Pretty much, yeah.
I would just caution the board because, yes, in either event, they would terminate the urgency ordinance. Certainly, that would be a possibility. I just think under the government code, because it says it can't be extended more than 12 months, we can put that provision in the motion, in the resolution. And also, I would recommend that it would say, and under no circumstances shall it be extended for more than 12 months, so that it meets the requirements of the government code. I'm just throwing that out there on the, I don't think it will happen. However, if, for instance, the initiative doesn't pass in May, and for whatever reason, which I don't think this will happen, but of course, as attorneys, we always look to worst case scenarios, that for whatever reason, a permanent ordinance isn't in effect within that 12-month period. I just want to remind the board that to have that at least as kind of a placeholder in the resolution. We can add that additional language. That would certainly be.
Yeah. Supervisor Tofinelli, I know you want to say something about that.
Well, no, I understand what she's saying, and I understand the whole demographics of the thing. I'm just going back to our meeting two weeks ago, where Supervisor Mills indicated that he would be willing to go forward a couple of months extending it. That was his comment, and Supervisor Claps was more or less the same thing. His was at least until an ordinance was in place. So I don't know if the 12 months period is because they feel that we would not be giving the staff any sense of urgency of going forward on a time frame by going forward on a month. So I'm trying to get to a compromised position to where we can have some type of insurance policy going forward that we can get 4 votes on versus walking out of here with nothing. That's my intention.
Thank you. We're still discussing your motion. Any comment, Supervisor Clapp, Supervisor Mill?
My thing is be this, what I ran on is what I ran on.
Okay.
And the commercial pot has no business where I live, none.
Supervisor Garamendi?
Again, I don't know what we gain. I don't understand what we would gain by not stretching it out as long as we can. This urgency ordinance terminates the minute, shortly thereafter, 30 days after, is either a permanent ordinance put in place by this board or a vote of the people. Should the ban pass, that's it. I get it, it's democracy. But, I don't understand what we gain by not doing this. And that would be my question.
Okay.
I would love to be enlightened.
All right. My comments are, once again, I will do everything in my power to make sure this county is left with proper public safety. If that means extending an urgency ordinance to the point where we have a permanent ordinance in place, I would consider that. But keeping in mind the opportunity, no, the right of the people to decide is foremost my priority. And I would recommend that we design, following Supervisor Garamendi's motion, a procedure to leave us in a position where we can take care of our own in public safety. If that means extending it past May 2nd, then so be it. But also, I understand Supervisor Tofinelli's issue about getting it done and getting it done right before a year's up. Now, I also understand Supervisor Garamendi's saying, what difference does it make? It's only good for a year. So, I'm going to let Supervisor Tofinelli repeat his motion. It's on the table right now, and then we'll be looking for a second.
December 31st. Can we take a 5-minute break? I want to consult with...
Sure. We'll take 5 minutes.
4 minutes.
I haven't turned them on yet.
Please let me know if it's on.
It's on now?
We good? Okay, ladies and gentlemen, we're back. We were discussing a motion made by Supervisor Tofinelli, and it hasn't been brought for a second yet.
I think
Mr. Tofinelli, you want to repeat your motion, or are we satisfied we can seek a second for your motion?
First off, I think it is the issue that has to do with my motion. It has to do with the resolution that was before us. I think County Council has crafted some different verbiage on that. And if you'd like to speak to what you have crafted on the resolution.
Would you like to withdraw your motion first?
Yeah, I'll withdraw my motion.
Okay.
At this point.
What staff would propose the board consider is in the resolution, it references on the
fourth whereas, it says, whereas if 45 days is an adequate period of time to adequately study the permanent ordinance, Government Code Section 65858 allows an urgency zoning ordinance to be extended twice by a Board of Supervisors before it either expires as a matter of law or is replaced by a permanent ordinance. And whereas the county extended the urgency ordinance on June 21st, 2016 to February 14th, 2017, and staff proposes that we add an additional whereas that would read, whereas this board wishes to exercise the second extension of the urgency ordinance pursuant to Government Code Section 65858. After that, the remaining part of the resolution would remain the same, except for the final paragraph where it reads, be it further resolved that the Calaveras County Board of Supervisors hereby extends urgency ordinance number 2016-0510-3069, which was passed on May 10th, 2016, and was extended on June 21st, 2016 to February 14th, 2017, for a period until it expires as a matter of law or is replaced by a permanent ordinance.
Is that your motion, sir?
That's staff's suggestion. I'm going to start with you, Supervisor Tofinelli.
Well, why don't we poll first,
Okay.
since I removed my...
Okay, you did withdraw your motion. Supervisor Clapp, comments?
I won't support that.
Okay. Supervisor Mills?
I will support that.
Supervisor Tofinelli, only because you're on that end?
I will support that.
Supervisor Garamendi?
Council, can you just read that fifth whereas one more time for me? I wrote it down, but I can't write fast enough.
What we were proposing is whereas this board wishes to exercise the second extension of the urgency ordinance pursuant to Government Code Section 65858.
I'll support that.
I would support that. Having that in mind, I would entertain a motion to that. I'm sorry. Go ahead, Mr.
One
Miller.
question, and it's really maybe directed to the county council. Would you want to amend the title of the resolution so it correlates with the finding, the last be it further resolved?
Yes.
So that language is the same.
Okay.
I would like to make one comment before you ask for a vote.
I have a comment, sir.
Okay.
I do not in any way want staff to take this as anything to do with being able to take their time on what directive they were given 2 weeks ago. The urgency to get our ordinance to us in a timely manner that we spoke of, in the time frame that we spoke of. I just can't stress that enough.
Okay. Thank you, Supervisor Tofinelli. Supervisor Mills, you requested.
Yes, my point is that as we look at this, we also have to understand the ramifications of Prop 26 and what role that plays in the outcome. And so I'm another one that, I was against Measure D, and I had a lot of reasons why. I do not think that the urgency ordinance has done what it was supposed to do. I'm looking at it from a process point of view that it was not successful. And, if we had to take it all apart and put it back together again, it would probably be a different animal. But it's not. It is what it is. And so we need to move on with getting permanence, and we need to get back to stability in our communities and get a sense of direction for our county. And this is the way to get it done.
Thank you, Supervisor Mills. I want to make sure that we understand this is not a ban ordinance, this is a permanent ordinance. Is that correct?
No.
This is
It's a
extension.
ban ordinance?
Extension.
Okay, all right.
Slow down.
Yeah.
It's getting late.
An extension, there we go. Thank you, Mr. Fry.
Of a
Give him a
temporary
jelly bean.
It's an extension of our existing urgency ordinance. Are we all in agreement on that? Okay? Well, having said that, I would entertain a motion for the extension of the urgency ordinance as dictated by county council and agreeance as far as the form with Mr. Mauer. Any motion? I'm sorry.
I will move.
Moved by Supervisor Tofinelli,
Second.
second by Supervisor Mills. Public comment. Oh, no, we already had it on the extension of the urgency ordinance. See,
Stop reading your note.
Yeah.
Keep reading it.
All right, ladies and gentlemen, we do have a motion on the table. It has been seconded, proper in content. All those in favor indicate by saying aye.
Aye.
Aye. All opposed indicate by saying no.
No.
4-1. Motion passes. Madam Clerk, when you're ready.
Supervisor announcements. In compliance with AB 1234, Chapter of Government Code Section 53232.3D, this is the time for board members to report on meetings attended on behalf of the county and to carry out their duties as county supervisor.
You have duties?
We'll start with Supervisor Tofinelli.
All right. I did attend the Mountain Valley EMS meeting last week, and I would like to say with great appease that Sutter Hospital has been given the designation as a level 3 trauma center.
Way to go.
So that is very good for our area here. You no
That's
longer
real
have to be
good.
transported all the way to Modesto. If something, a trauma, in a car accident, you fall off a ladder, what have you, they will transport you to Sutter Hospital. So I thought it was great. And that's all I have.
Okay, Supervisor Clapp.
Well, I went to CSAC with my two buddies,
There you go.
and we had a good time. They tried their best to educate us, but it was a tough one. And let's see, what else did I do? That's about it. Oh, I went to the Sweetheart Dance. Believe it or not, they invited me.
Oh.
And so that was fun and everything. That was for the Kids Drop-In Center over in Valley Springs. And so it's a fundraiser and stuff for them. They're having a lot of problems and stuff, you know, financially and stuff. But yeah, it was a good dinner.
Thank you. Supervisor Mills.
Yeah, the dog didn't eat my homework this time. Let's see, 28th of January, I volunteered for the Copper Run, which benefits the Friends of the Library down there and the fire department and the school. Also had the Murphy's Fire Appreciation Dinner. My wife was a former board member. Calaveras Mariposa Community Action Agency, we assisted in development of their strategic plan. There was a council of governments meeting that night. Highway 4 meeting, we discussed the grants for tree mortality, status of the UWPA remap project, working together on the WIN Act proposal, the governor's order to the water districts. And then February 4th was the Lions Crab Feed in Copperopolis. February 7th, the Angels Camp Business Association Coffee Talk Tuesday, discussing business opportunities. It's always a different discussion every time we go there, so it's kind of cool. Met with members of CSA 2 on ongoing road issues on Stallion Way. February 8th, Mark Twain Hospital District Finance Meeting, Public Works. Angels Camp Business Association mixer, February 9th and 10th was new supervisor training with Supervisor Garamendi and Clapp. And then February 11th was the Angels Murphy's Arnold Boosters Crab Feed. Tomorrow I'll be with Camera and UPUD, and then Thursday I will speak at the Rotary and Murphy's and also to the Copperopolis Homeowners Association.
Thank you, Supervisor. Supervisor Garamendi.
Thank you very much, Mr. Chair. Had a busy couple weeks. Went over to Frogtown to meet with the Fair Board, really talking about how we're going to revision that space as we look at the next 50 years. I think we all value the frog jump as it's an important part of our community. Also met with AT&T to discuss how we're going to bring both internet and cell service up country. Everybody knows that once you head up the hill, you're out of range till you get back. First meeting with the first 5. They are really a great group of people and have really great plans for our 0 to 5-year-old children in our community. Mental Health Board, it was very interesting. They're excited to see how they work with our jails and our deputies out in the streets to sort of prevent, as a preventative measure and to assist them. CSAC training, I got to hang out with these guys and we learned about the Frankenstein called the state and local and federal budgets and how they interact with us. And I don't know about you guys, but my head was spinning by the time I left that room. That was very intense. West Point Library had a great event. Librarian was up there in West Point this weekend. We were really pleasant to have Ms. Giddens join us. We're very fortunate to have such a great librarian. Got to throw a shout out to Marty Crane and the Volunteer Center for winning the Golden Health Awards put forward by Mark Twain. I think it's a great recognition of the work that you and other volunteers do in the community. Thank you very much. And then a plug for Mountain Ranch Central Flyers having a mud run on May 13th. So any of you guys, that's right, I understand you're announcing and I'm running it. So how'd that work out?
They roped us both in, but at least you'll be in the mud and I'll be high and dry.
Appreciate you having me back there, Gary. Anyway, I will post it on the web and hopefully lots of people will attend. I do have one item, and Mr. Chairman, you said we would, if we wanted to add things to discuss, we should bring it up in this form. I'd like to take a poll, just finding out, I feel like we need to start coming up with the county space plan in a formalized manner. I know we had an agenda item today. We took a step back, but as you go around and you look at our roofs leaking and our paint as high as you can reach, and then where people are going, it seems like something we got to formalize in a process.
Supervisor Garamendi, we can take a poll for the board on that. I'll start with Supervisor Clapp, work down the line. Would you be willing to discuss that as an agendized item in the very near future?
Yeah, I think it needs to be.
Supervisor Mills? Yes. I would also encourage that and support that. Supervisor Garamendi, I hope you would support it.
I hope you would.
Yeah.
I'll support it.
Great.
Okay, so just to help me out,
That's me.
if you actually say instead of nodding, because I'm not looking.
Yes.
Garamendi, aye.
I think it's 5 yeses.
Okay, thank you.
I think that was unanimous. Is that
Okay.
okay?
And
So we can look forward to
I don't
that.
think it's immediate, but we need to start moving in that direction.
You're right. You're absolutely right.
Mr. Chairman, that concludes my lengthy report as always.
Good report. Thank you. I attended on the first, the EPOC meeting, Ebbets Pass Property Owners Committee. It's a collection of all the homeowners associations up on Highway 4 corridor, if you will. Always a good meeting to attend and provide county input on the basis of my participation as supervisor. Good way to get the word out to all of our folks up in that area. We did have a law library committee scheduled for that afternoon and was canceled at that last minute, so we'll be rescheduling that. My phone's not performing well. I did meet on the 8th with Public Works, and we discussed some projects underway in District 3. Some problems we have due to the storm damage. That is a continuing problem because we have anticipated some more moisture coming down. So hopefully we won't suffer the damage that we did this last event. We attended the agenda review on the 14th that afternoon. And on yesterday, I attended Sacramento, the Governor's Task Force on Tree Mortality. We had a coordinating meeting of the rural counties at 10 o'clock. Then we had the actual governor's meeting at the Capitol at 1 o'clock. That program is moving right along as far as our state funds can take us. There is a concerted effort to lobby for federal funds, and there is a legislative session in Washington, D.C. with NACO that several of our local supervisors from Amador County and from Tuolumne County will be up there positively lobbying our representatives for FEMA to take part in this tree mortality program. So I'm not going to Washington DC, folks. But that's very encouraging. We have representation one-on-one down there. It's a situation where voices must be heard by the right people. With that, I have nothing else to report.
Big shout out to our member agencies for helping us.
By all means, yes. We did have some exciting response from U.S. Forest Service, CAL FIRE, PG&E, Caltrans, for taking care of our tree problems up here now. Highway 4, the Caltrans has just about completed their work. They're still ongoing, and they're slotted for Highway 26 next, and that'll be coming up. And we were assured that there is funding now for 2017, so that program will be ongoing and continuing. So, good job. Thanks. That's all I have. Staff? Nothing from staff, nothing from CAO, nothing from... Ladies and gentlemen, I want to thank you very much for attending today. Time to go home.
Happy Valentine's Day.